permitted to mention one matter. Lord, the matter relates to the public premises eviction of Furniture Act. Plus, the matter was supposed to come today in the list. When yesterday my London junior came and talked to your lordship's court officers, he told that matter will appear. But unfortunately, the matter has not happened. My client has come all the way from Maharashtra. He's about 85 years. He came for the very few matters are there in the list. Your lordship may kindly place the matter tomorrow or on Monday, subject to lordship's convenience.
Tomorrow it may not be possible. Next. बोलो फाइल ना दीजिए मैटर আসবে না এটা একটা ফাইল হয়ে গেছে আসবে না কেন You give it, it will appear.
Much of this. Last week, the can one has not.
হ্যাঁ দিদি ওই ওনার একটা ক্যান ওয়ান আছে ওই না না ঠিক আছে লিস্টে আনতে হবে আর্জেন্ট থেকে আনে
It's running to 667 days.
ওটা আর্জেন্টলি খুলে দিন কারণ ওটা ওনার আর্জেন্সি আছে ওই একটা কালকে তো হবে না সোমবার Yes.
May I kindly be permitted to one urgent listed matter of my lord Justice Hiranmoy Bhattacharya, my lord. My lord, my vehicle has been seized by the ADM.
When was the seizure done?
Seized, my lord, on 30th December 2020.
So you have time.
My,
Next
my lord.
His lordship will be there.
My lord, may I be allowed to mention of matter? My lord, the matter was filed a long time back and the file was lying in the court of Honorable Justice Rajabhat.
Give it, it will appear.
My lord, there are some other matters also. Since the file was lying in the court.
If the matters, they will appear. No need to mention.
Mentioning for withdrawal. Serial 124.
Didi ota non-prosecution e diye debe. To be mentioned. To be mentioned, they appear for withdrawal.
The lordship may forget to mention a matter for upgradation. My lord, the urgency is that recovery note has been issued. My lord.
You have mentioned it in this.
Yes, my lord. I've taken on the.
My lord, may I be permitted to move this, my lord, petition as an urgent matter, my lord, unlisted motion, my lord. Urgency is this, my lord, with behind back of the petitioner. My lord, demolition order was passed. My lord, demolition will be, my lord, held within 2-3 days, my lord.
File it, serve it, it will come.
My lord,
No unlisted.
my lord, demolition proceeding will be start, my lord.
Sir, I have said no unlisted means no unlisted. You file it, give the number, it will appear, serve them, let them come. No unlisted.
Lordship, this is a motion matter where cash to the tune of 1.39 crores has been seized. The Lordship knows that this matter is settled. There's been no correlation between the cash seize and the tax evasion that the respondent authority is trying to meet out. Lordship, since the amount is substantial and since a motion matter, the Lordship could kindly take this up urgently.
If this mention the grounds.
I have mentioned.
Appear as urgent motion.
Lordship, item number 599, it's appearing under the heading unauthorized occupants. Lordship, today is the date fixed for demolition, Lordship. It's appearing for.
It will be taken up today.
Lordship, by chance, if it's not taken up, maybe it be taken up before.
If it is not taken up, we'll hear.
We shall put them on
The other
notice.
side is there.
Grateful, Lordship, grateful.
My lord, leave is not required, my lord.
It's unauthorized occupants act matter. Why leave is required? Unauthorized occupants act, I have determination. You file it.
File it and my lord, give the number to your.
Yes, after filing, you give the number to the officer and serve them.
Yes, yes.
Because it won't be taken up tomorrow, next week. It won't appear tomorrow.
But in this instant matter, the order is supposed to expire on 31st of December 2025. And the lordship was not supposed to be on 16th of December. It's appearing as item number 721 of the list. The lordship will kindly keep it under the heading to be mentioned tomorrow. In what?
For what?
For extension of the interim order, or if your lordship.
Extension of interim order.
Great.
Jyotikar matter, should we take it after the vacation? What should we do?
Tomorrow and the lordship next.
Can my lord, I'll take 2 to 3 minutes.
Either tomorrow or
I'll take whatever my lord.
What has been passed, lordships? Now I have also time to go for appeal also, and if that order is quite because there was no show cause hearing also done. If I am relegated back also, it will be not time but lordships.
Subject to lordship's convenience. Whatever.
You will not be
no
there next
difficulty,
week.
lordships. Monday, Tuesday, I am not there, lordship. That is
Then let it be there in the list as it is.
my junior will be there. If
Yes, after reopening, you mention we'll
My lord. Both of us will mention.
Lordship.
Yes. Call করুন।
Item number 1 and
I appear for respondent number 1 and 2. I appear for respondent 1 and 2 in both the matters.
Yes,
I'm
sir.
sorry, my lord.
Why are you
I am
not physically present?
I am sorry, my lord. I could not be physically present because of the preoccupation of this spondylosis. So, my lord, I shall just formulate the questions of law. Mr. Kumar Jyoti Theory, senior advocate, is representing me. He is stationed there. He will complete the other question or arguments. Now, may I just take 10 minutes, not more than that?
Yes.
Now, my lord, what is the instant case? The prayer is the apprehension of issuance of a notification pursuant to the order passed by the designated authority. Therefore, this is apprehension. That notification has not been passed as yet. And your lordship is aware, if the notification is passed, there is a provision for appeal. Now, this appellate forum, the alternative remedy, has three facets. One is arising out of an agreement between the parties, like arbitration or any other appellate forum. The other is a general statute, like the Specific Relief Act, Section 41, Section 41H, your lordship is aware. If there is efficacious remedy, no interim order shall be passed under Section 41H of the Specific Relief Act. And if there is efficacious remedy, there shall not be any interim order passed under Section 41. Then, my lord, under the general statute, general special statute, under which this adjudication is made, whether there is an appellate forum, yes, there is an appellate forum, a comprehensive, it is a complete code, and there is a provision for appeal. Therefore, when an appellate forum is there, the only question of entertaining a writ petition is on the mainly ground of Whirlpool Corporation's case, whether fundamental rights are infringed, whether it is without jurisdiction, mainly 2 points. It has been, the authority, designated authority, in a detailed order, has maintained the procedural propriety. There is no illegality in the order passed by them, and there is no question of jurisdictional error. They are authorized under the Act and the rules, and that there is no infringement of fundamental rights, because absolutely this is coming within the score of absolute question of alternative remedy, and no writ petition lies. Because there, the question of maintaining a writ petition, even if there is alternative remedy, lies only when there are specific infringement of fundamental rights and jurisdictional error. It is not the case here. Therefore, on both Specific Relief Act Section 41H and under the special statute, there are efficacious alternative remedy that has to be availed, and that too after issuance of the notification, not when their right will be infringed specifically therein. This is the case of alternative remedy. Possibly this has been exhaustively argued by the learned advocates, especially Mr. Salve, learned senior counsel, and Mr. Devasis Basu on the last occasion. Therefore, alternative remedy is not the question here, because their procedural propriety has been maintained by a detailed order. There is no illegality, no arbitrariness. Second is, my lord, that your lordship is aware, Section 41H, Section 41I of the Specific Relief Act says that if there is conduct of the party is bad, then the question of interim order shall be not be there, and there shall be interim order shall be refused. The conduct is that there are misrepresentation on the part of the writ petitioner about the question of cause of action, and subsequently it has been managed. An attempt has been made to manage this by filing a supplementary affidavit that in respect of an export from Haldia, and that to in 2025, and the cause of action for the adjudication of this particular case is up to the financial year or up to 2024. Therefore, what has happened in September 2025 cannot be the cause of action here for maintaining a writ petition and territorial jurisdiction under Article 226(2). Therefore, this is absolutely not maintainable. And thirdly, that your lordship is aware under Specific Relief Act section 36, injunction is absolutely a discretionary remedy. Your lordship may grant injunction, may not grant injunction. And this absolute apprehension, there is no apprehension and there is no question even on Order 39 Rule 1 and 2 principle. Now comes the moot question of territorial jurisdiction. Well, all the respondents, the petitioner, the respondents, the orders passed, all at Delhi, and the petitioners are deciding outside India. They are not importer, they are exporter. Therefore, the question of territorial jurisdiction, it has been exhaustively argued. I want to draw only your lordship's attention to only one paragraph of the latest judgment of the Apex Court in 2023, volume 7, SCC, page 791. Possibly my lords have gone through this judgment, has been referred to only on this question. Even if part of cause of action arises, whether the 226(2) is attracted. That is the conclusion of the latest Supreme Court judgment. My lord, at page 21, I am reading just short paragraph. Even otherwise, the High Court was not justified in dismissing the interim applications, assuming that a slender part of the cause of action, this is important, did arise within the state of Sikkim. The concept of forum convenience ought to have been considered by the High Court, as held by this court in such and such, even if a small part of cause of action, this is important, my lord, arises within the territorial jurisdiction of the High Court, the same by itself would not have a determinative factor compelling the High Court to keep the writ petitions alive against the appellant to decide the matter qua the improved notification on merit. So therefore, even if 2025 Haldia export is taken into consideration, that is not within the zone of consideration by the designated authority. That is absolutely a desperate attempt to bring it to the notice of the Honorable High Court of Calcutta and invoke the jurisdiction. It is not maintainable. Then the last point I am arguing is that your lordship will kindly consider, even on merit, if the question has been decided whether they have an obligation of to pay the duty on the question of anti-dumping. They have an obligation. They are the exporter. They have an obligation. Therefore, it's a question of revenue matter, a fiscal legislation. They are duty bound to pay the amount. And in the event your lordship decides to admit the writ petition, they have to pay secure the amount, entire money. And the rest part, my lord, Mr. Kumar Jyoti Tewari will satisfy the lordship on my behalf. Kindly allow me, my lord. My lord, may I? Mr. Kumar Jyoti Tewari is there, my lord? First. শুনতে পাচ্ছি না কেন? এটাই তো আছে। হচ্ছে না। এই একটা কথা। কুমার জ্যোতি আর্গুমেন্ট করছে।
it corresponding to 119G. Now, if this presumption applies, now, if 114G of the Evidence Act is applied, then it has been done rightly. The authority, what authority has done? Authority has relied on the best information available on record to compute the cost of productions. And next paragraph, paragraph 160. Further, Equate Group failed to provide a sufficient justifications for not allocating the certain cost, which should have been allocated to PUC. The explanation provided by the Equate Group was found to be at variance with the information submitted for verifications. Accordingly, the authority has allocated such costs based on the information available on record for these investigations for determining the cost of productions. So, authority had proceeded after taking into consideration all these things. Now, kindly just kindly takes so far as procedural illegalities is concerned, your lordship kindly takes 2 paragraph I will be showing to your lordship. They have pleaded paragraph 33 and 35. Kindly come to paragraph 33. Or prior to that, I just place paragraph 32. Page 23. Now, it says, your has you also got it? Your prisoner states that the said impugn final finding are vitiated by very serious procedural irregularities and substantive errors inter alia. Number 1, non-disclosure of the essential facts under consideration contrary to Rule 16 of the AD rules and Article 6.9 of the WTO anti-dumping agreement. The arbitrary and inflated cost constructions for the foreign producer exporter contrary to Article 2.2.1 of the WTO agreement. The selective injury analysis confined to RL while ignoring the data of IOCL or IGL, rendering the injury assessment non-representative. The erroneous causation and failure to establish any genuine link between your petitioner's export and the alleged injury to domestic industry. The failure to undertake the meaningful examinations into public interest and downstream effect on the Indian polyesters value chain. Now, manifest non-applications and internal contradictions and mechanical adoptions of RIL submissions without independent analysis. These are the grounds for appeal. These things can be agitated before the appellate forum, not before this honorable court. This contains highly disputed question of facts. Whether your lordship would go into all these disputed question of facts or not at this stage, that is to be looked into. Now, next paragraph, paragraph 33.
Yes.
Paragraph 33 says, your prisoner states that these infirmities are not mere procedural defect, but go to the root of the decision-making process, rendering the impugned final judgment wholly void and unsustainable in law. Your petitioner submits an impugned final judgment thus suffers from violation of principle of natural justice, non-applications of mild procedural impropriety, and rendering them liable to be quashed and set aside by this honorable court. How it has effect? How it has prejudiced him? There is no pleading to that effect. Barely saying there is violation of principle of natural justice, a non-application of mine. How authority did not apply it mine? That is to be, there has to be specific pleading to that effect. Now, I just show to your lordship another 2 paragraphs. That is paragraph 35. Paragraph 35, my lord, at page 25. It says, my lord, your petitioner states that it has no efficacious statutory remedy against such finding prior to their implementation by the Ministry of Finance. Your petitioner further submits that although the Section 9C of the Custom Tariff Act 1975 provide for an appellate remedy before the assessor, no dedicated anti-dumping bench was functioning for a considerable period, rendering the remedy effective in practice. The bench has only recently resumed the limited sitting and also categorically held an appeal under Section 9C lies only from a custom notification issued by the central government under Rule 18 of the AD rules and not from the final finding of the designating authority, which is a mere recommendatory, and a copy of the sister order such and such and such. So, my lord, he has admitted, well, so far as petitioner is concerned, my lord, he has admitted that it is a premature writ. It is his admission. It is absolutely a premature one. Well, there is no cause of action as on date. The custom has not issued any notification in terms of Rule 18 till date. It is his case, my lord, there is no, it is recommendatory in nature. My lord, what will happen if notification is not come by 22nd of December? The entire exercise will go. So, until a notification is issued by the central government, there is no cause of action at all. It is the entire exercise is actually nothing but a premature exercise, and it is approach is also a premature one. Now, my lord, your lordship, my lord, kindly, so far as invocation of this honorable court is jurisdiction is concerned, my lord, only two things. My lord, your lordship, my lord, kindly turn, my lord, page 42 once.
Yes.
Page 42, my lord, I'll just place, my lord, last 5 lines. Now, my lord, it starts from the sentence. The same details were additionally presented. My lord, from bottom 5th line.
Yes, yes.
The same
10.
details were additionally presented in the format of Appendix 10. Your petitioner also explained and substantiated that the average purchase price of the ethane for your petitioner was consistent with the prevailing chemical market analysis benchmark, and therefore the reflected an arm's length price. The non-submission of the complete feedstock agreement by your petitioner is immaterial, as your petitioner had placed the sufficient information on record which allowed the respondent number 1 to determine whether your petitioner's purchase of ethane were at market and arm's length price. Indeed, there does not exist any requirement under the AD rules which necessitated an authority must specifically procure a respondent's feedstock arrangement, and the determination of the transactions at the market prices can only be conducted on the basis of such agreement. Now, my lord, I am asking for document. You are not supplying the document. Now you are alleging the violation of principle of natural justice. You are withholding your own document. And my lord, so far as my lord, invocation of this jurisdiction of this normal code, only one paragraph, my lord, that is paragraph 31, page 54.
Yes.
Now, my lord, kindly may I just place paragraph 41. Paragraph 41 says, my lord, your petitioner states this normal code hand arises within the territorial code where an impugn order is implemented. Your petitioner highlights that the bona fide customers of the MEG located in Calcutta procured your petitioner's export via Haldia port. Indeed, in the financial year 2021-22, 19,526 metric ton of your petitioner's export of MEG were purchased by such and such industries limited, a customer in Calcutta. However, the imposition of anti-dumping duties would require such customers to pay significant additional duty of such and such and such for a further period of 5 years at Haldia port, a duty that is not payable for domestic producers of such and such and such. This is our hypothesis and anticipation. What will happen after some time? There may not be any notification also. What will happen after 22nd of December? Nobody knows. If the notification comes after up to 22nd of December, then everything is okay. Otherwise, the entire process, entire thing will go. So, these for the purpose of if suppose today your lordship is suppose any order is passed in West Bengal, whether it has effect in Gujarat or not, that does not give the jurisdiction of the Gujarat High Court to entertain the writ petition on the basis of the notification issued by Government of West Bengal. And so far as this point is concerned, my lord, I just point out to you, my lord, supplementary affidavit. Mr. London SG, my lord, has submitted, my lord. They tried to improve their point of territorial jurisdiction, my lord, by filing one supplementary affidavit. Now, my lord, your lordship, my lord, kindly takes the supplementary affidavit which was affirmed on, my lord, 4th of December 2025. Well, only one paragraph I will show to your lordship. That is paragraph 4. I say inadvertently, the details of export of monoethylene glycol (MEG) by your petitioner to the Haldia port were excluded from the repetition. A purchase order for MEG was issued by such and such to your petitioners on October 13, 2025. Following your petitioners generated a commercial invoice on November 3, 2025. Your petitioner disbursed the consignment of MEG on November 3, 2025. The gross weight of such and such, and a bill of entry was generated by such and such. But this is done, my lord, after, my lord, this order was passed. And, my lord, so far as, my lord, violation of now, my lord, only 2-3 judgments I just show to your lordship, my lord. First one is, my lord, regarding, my lord, 226(2), my lord, there is a division bench judgment of our High Court. Just but this is, my lord, MAT 112 of 2024. Judgment delivered by the division bench will have preserved by Division Chief Justice, my lord. Just, my lord, your lordship, my lord, kindly turn, my lord, paragraph 13. The Honorable Division Bench will not quoted all the more or less all the judgments will not offered in this field. And thereafter, my lord, kindly see, my lord, paragraph 14. It says, my lord, Article 226 of the Constitution of India states the power conferred on Clause 1 to issue orders, directions, and writ to any government authority on the persons may be exercised by any court exercising the jurisdictions to in relation to the territories within which the cause of action wholly or in part arises for exercise of such power. Notwithstanding that the seat of such government or authority or the residence of such persons is not within those territories. Now, well, these are the well settled law. Now, carrying paragraph 17. It is well settled expression that the cause of actions means a bundle of facts which the petitioners must prove. If traversed to entitle him to a judgment in his favor by the court, an objection as to the lack of jurisdiction has to be decided by the court after taking into consideration the facts pleaded in support of the cause of action without vouching the truth or otherwise of such facts. Now, Saika property was quoted, then ONGC was quoted. Now, National Textile Corporation, ONGC, National Textile Corporation, all from Calcutta. All these judgments were quoted. Now, paragraph 21. Paragraph 21, last 3 lines, emphasis supplied by the court. I'm just placing last 3 lines. Paragraph 21. It was quoted. The facts which have no bearing with the lease or dispute involved in this case do not give rise to a cause of action as to confer the territorial jurisdiction of the court concerned. Here, entire writ petition, I do not find anything which can invoke the jurisdiction of the Honorable. Nothing is there. Subject to correction of my learned senior friend, nothing is there, which can invoke the jurisdiction of this Honorable Court. Now, the next paragraph 22. The Honorable Supreme Court further held the mere fact that
Adani is quoted actually.
Adani is quoted. Adani is quoted. Now, paragraph 22 says, the Supreme Court further held the mere fact that writ petitioner carries on business at Calcutta and the reply to the correspondence made by it was received at Calcutta is not an integral part of cause of action. Therefore, it was held the Calcutta High Court has no decision to enter in the writ petition. Kindly take this paragraph 22 with paragraph 31 of the writ petition. The problem will be solved. Paragraph 31, the answer is given paragraph 20. Now, these are my submission. Only one thing, so far as principle of natural justice is concerned, I just cite one judgment. This 2007. This is 2007 4 SEC 54. I'll just read to 2007 4 SEC page 54. Ashok Kumar Sankar versus Union of India Annals. Now, if state lottery comes to paragraph 26, I'll be relying to paragraph 26 to 32. Paragraph 26, says, this brings us to the question as to whether the principle of natural justice were required to be complied with. There cannot be any doubt whatsoever that the audio alternate party is one of the basic pillars of the natural justice, which means that no one should be condemned unheard. However, whenever possible, the principle of natural justice should be followed. Ordinarily, in a case of this nature, the same should be complied with. The visitor may be given a situation issue notice to the employee could be affected by the ultimate order that may be passed. It may not be an oral hearing, but may be followed by the representations in writing. It is well settled that it cannot be put any state jacket formula. It may be applied in a given case unless the prejudice is shown. It is not necessary where it would be a futile exercise. The court of law does not insist on compliance of useless formality. It will not issue such directions where the result would remain the same. In view of the fact situations prevailing in the terms of legal consequences, furthermore, in this case, the selection of the appellant was illegal and he was not qualified on the cut-off date and being ineligible to be considered for the appointment, and it would have been futile exercise to give him an opportunity of being heard. Now, we'll at paragraph 29, Aligarh Muslim University was quoted, where it has been stated that the principle of natural justice is sometimes useless formality, and ultimately it was said, it depends upon the facts of particular case. There was a paragraph 30, the Karnataka SRTC versus SG Karnataka was also quoted, where just Supreme Court said, the question to the extent the principle of natural justice are required to be complied with would depend upon the fact situation obtaining in each case. The principle of natural justice cannot be applied in vacuum. There cannot be put in state jacket formula. The principle of natural justice are furthermore required to be complied with when it will lead to an empty formality. What is needed for the employee of this nature to apply the objective criteria for arriving at the subjective satisfaction. If the criteria required for arriving at the subjective satisfaction is fulfilled, the principle of justice may not be complied with. In view of the facts, the same should comply with before imposing punishment and all these things. So my submission is that after taking all these things, authority concerned arrived to a finding. Now, this leak is absolutely premature one. The all opportunity of hearing was provided to them. So, there is no case made out for principle of natural justice, violation of principle of natural justice, and paragraph 31 does not give any jurisdiction to this honorable court. And so far as this we have followed in strict sense, judgment delivered by the Supreme Court, there is ATMR. This is 2011 2 SCC 254, Automotive Tire Manufacturers Association. Automotive Tire 2011 2 SCC 258. Well, here what happened, here in this case, ultimately order was set aside for violation of principle of natural justice. But in this case, ultimately what happened, that heard by one DA and judgment delivered by another DA. Only on that ground, it was set aside. Only on that ground. Principle of natural justice was vigorously argued by Mr. Bagaria, and his argument was accepted. But this is the case, where, in fact, DA, I just point out to you, the one thing. Kindly take, paragraph 6. Paragraph 6 of this judgment. It says, the DA granted a public hearing to all parties on 1/9/2004. However, on 1/11/2004, an officer functioning as a DA who had conducted the investigation in that case was transferred. A new officer took as a DA. On 6/1/2005, the appellant hearing, in particular ATMA and certain request the newly appointed DA to grant fresh hearing before finalizing his report and recommendation. On 12/1/2005, DA sent a disclosure statement to all parties concerned. On 17/1/2005, the appellants wrote a letter of protest to the DA, entirely confident that their submissions were not examined. Newly appointed DA had failed to grant them public hearing, and the sum of the new submissions made by the domestic industry form part of the record. So, only on this ground, the entire thing was set aside by the Supreme Court. But here is not such a case. These are my submissions. very quickly, my lord. My lord, very quickly, my lord, I'll just try and wrap it up, my lord, because my lord, mostly submissions have already been made by Mr. Salve where he's leading me. So I'll try and keep it to that extent where I need to say something which I'll not repeat of Mr. Salve. But my lord, the first thing, my lord, kindly appreciates, my lord, we can't have a matter in the air. We are all bound to pleadings, my lord. As a matter of fact, your lordships have held clearly evidence beyond pleadings, not acceptable. Anything not to do with pleadings, not acceptable. So, my lord, I will again beseech your lordship to just see the pleadings on territorial jurisdiction.
Yes, I was taken through them.
I'm not reading it. My lord will kindly appreciate. I'll be very specific. In para 37, I'm not taking a lot through the whole thing, but I'll just point out certain statements. In paragraph 37, he says that the honorable, or they say that the honorable courts have repeatedly held that a writ under Article 226 lies where an order is patently perverse and violative of natural justice. Now, may I just wait here for a moment. Therefore, his cause of action is violation of natural justice. If that is the cause of action, Malad knows better than me. Malad, cause of action, you will have to point out where this violation has taken place. If your lordship just keeps note, it is their letters, as a matter of fact, which your lordship will find. Now, these are at pages, volume 4, pages, Malad, 561, 562, and a few more thereafter, 565. But these are the letters which my learned friend has been relying on, and obviously his client has been relying upon, where he writes, or where they write, to the office at Delhi. Well, if the office is at Delhi, Malad, and if he pleads violation of natural justice, well, it's something which is factual, then something must have happened or something must not have happened. Then he has asked someone from Delhi, and that has been refused in Delhi. Because Malad 226(2) says cause of action. Here, Malad, they are coming before your lordship in a special cause of action. Because they say there is an alternative remedy. They accept that. There is no dispute about that. But for violation of natural justice. Then natural justice becomes the cause of action. Now, in this viewpoint, Malad will kindly have a look at 41, which is the other paragraph. Malad kindly sees how it has been couched, Malad. Your petition says this honorable court has held that a cause of action arises within the territorial jurisdiction of a court. Now, mind your kindly notes, where an impugned order is implemented. Now, there is no implementation of this order here. There might be, but not of this order. There has to be a notification first. Then he can take the point that yes, it will be implemented. Then, he assumes territorial jurisdiction on these 2 points, where everything has happened in Delhi. Now, my learned friend has also shown certain, by way of supplementary affidavit, that there are dealings of. Then, if that is the case, a person will have multiple jurisdictions if he is all over India. That is not the scope. The scope is we have to show the cause of action. That's why what is cause of action? Material facts. It's not all facts. Therefore, your lordship will have to assess. Kindly appreciates. 226(2) would be, I wouldn't state and say, but it is in that, it is not the rule. It is more in the nature of an exception. Even Rikhapchand judgment says so. Your lordship, Mr. Khaitan, when he started arguing, he also said whether this is under 9C, could this be challenged or not, that is pending. Let us see that. Where is it pending, if I may ask myself this question? This question is pending before the Delhi High Court. Now, Recaptain Jain is not a simplicity judgment. It requires us to go back a few decades where it was held that you cannot use 226(2) to pit one court against another. First, it said alternative remedy. And then it said that which is the correct forum or actual forum where it could be challenged. Now, my lord, it is undoubted and undisputed that this question is before the Delhi High Court. It cannot be also doubted by my learned friend that if he goes to Delhi, that could be natural. Because the original authority is in New Delhi. So today, my lord, if your lordship is being now set up, my lord, which you kindly does not take my words may not be correct, is being put against the Delhi High Court. And your lordship will notice absolutely this case which has been made out. And in Recaptain Jain, my lord, kindly just please note out, my lord. And it's already in the compilation, my lord. I just point out the paragraph, my lord, so that I'm not going to read it again.
Page is there, the Recaptain Jain.
Page 49, my lord.
Petitioner.
The heading is wrong, not nice.
Sorry, sir. Heading of the compilation.
The heading of the bullet. I'm sorry, my lord. The kindly keeps note of para 8 onwards, my lord. It starts with, however, if you got you once I can hand over again, my lord.
No, I should have it.
However, this particular appeal unfolds.
It's an unreported version.
Yes, sir. We have given an unreported verdict number. And I can hand over a reported one if you want one. May I?
That will do it. It's the same thing.
But a para 8, if your just has a look. However, this particular appeal unfolds a fact situation which requires consideration of the issue from a different perspective. It wasn't just a simplicity process too. But constitutional decisions of high authority just seemingly faded into obscurity, but the significance and impact whereas have continued relevance. While deciding whether to enter the petition under Article 20, bearing in mind the precedence in the field, a writ court ought to additionally notice the forum designated by the statute for the litigant to approach. Now, my lord, I am trying to come in here, my lord. The forum is the appellate court. Now, the substitute court is the writ court. My lord, they are very well aware that that question is pending before the Delhi High Court. And that is precisely what has been stated here. However, as you know, the statutory designated alternate for happens with the High Court itself, whose jurisdiction is invoked. Refusal to enter in the petition should be the rule and entertaining as an exception.
Right.
So therefore, while Mr. Haitan was submitting that the question of 9C is still pending, that will also be here. And they have assumed jurisdiction on the basis of that earlier writ petition, which is no more there. So by the pleadings, Malad, that is what they have done. Now, Malad kindly sees Malad will kindly keep note, violation of natural justice has been pleaded, Malad, primarily, Malad, in paragraph 26. 26, 20 and 28 of the writ petition.
26, 28.
Malad, which specifically says that they had approached the authority. And where is the authority? We all know. So that is his cause of action. Now, grounds, if your lordship will kindly see, Malad, the mention would be in grounds 3, 5, 8. 9, 12, 14.
Yes.
Now I'm not reading them, but it will kindly notice them. So these are the grounds. And these are the grounds which clearly say the violation is that. And the other ground, they say that the order is wrong. The order is wrong. So, Malak, this is part of the territorial jurisdiction. Now, Malak, it is linked with Malak, the alternative remedy now. Because if the other ground, per se, Malak, straight away goes to the point and the root of the matter that you have not adjudicated properly, Malak, then it's out. Immediately out. And very interesting, Malak, kindly appreciate, Malak, once you allege violation of natural justice, then it should have been linked that the findings are wrong because there is a violation of natural justice. They otherwise challenge the order also on facts. So that is very important. Your Lordship will kindly notice that. Then, Malak, Malak, two things I will only mention, Malak, though I do not wish to go into the merits, because if I go into merits, Malak, I will fall into the trap. I will not go into the merits.
No, in fact, nobody has.
No,
Mr.
Mr. Khaitan, to show as violation of natural justice has gone to
From
the
the very beginning,
but
the
I will not go.
understanding was that we are proceeding on maintainability, and
That
if it was on
Absolutely
merit,
correct.
then affidavit would have been invited by this
because
court.
Mr. Khaitan has relied on several parts of it to show violation of natural justice. I am therefore trying to bring him back to his pleading, so that I don't need to go that way.
Because he was required to show violation of natural justice to stave off that alternative remedy point.
I know, but I am holding him back into pleading. So that is what he pleaded. He hasn't gone beyond that. So that is what I am trying to do, Malak. But the only thing is, Malak, there has been redaction.
In the process, I have been taken through the entire
Entire
by all the three.
No,
In fact, I have read the entirety of it because everybody has shown tidbits of it. So if you join all of them, the entirety of
now, I don't know the question of
pages.
But I'm just trying to show your Lordship will also consider another thing, which is very important, because I've been trying to also appreciate myself. Which comes first? First jurisdiction or first violation, then merit. And if I can show there is
No, has to be territorial first, because I will enter into the domain of alternative remedy or not, even only when I have jurisdiction. First, I have to have jurisdiction. Now, this is on twin grounds. Your challenge is on twin grounds of maintainability as well as entertainability. The first ground of territorial jurisdiction is maintainable. It will not be maintainable before me because I lack jurisdiction. If the petitioner crosses that threshold and I am holding in favor of the petitioner, it is only then that
violation
I
of
will have to
natural
answer the question whether I will entertain it or not. The question of exercising discretion will arise only when I have jurisdiction.
Absolutely.
If I don't have jurisdiction, if I am denuded of jurisdiction, I don't have discretion.
Absolutely.
I cannot.
But I am on another point, which I am right about to take, Malak, is what would be the effect if I can show on the face of it that whoever has come before your Lordship is guilty of tedious suppression of fact. Then what happens? That is what I want. Because Milas will kindly, because Mr. Khaitan's client has been very fair in saying that I have redacted what is supposed to be information, confidential information. But your Lordship will kindly go through the redaction. Your Lordship will find questions made by the government repeatedly has been scored through, redacted. But the redactions can be made of data. You don't make redaction of proposition. And let us say the government asks for some data on some, but that should remain. You don't give the data. I understand. Like it has been shown in stars, but you know against what? And there I say, my lord, if that is the case, I am a adversary litigant here. You cannot proceed in the writ petition without showing me that. And a very recent judgment of Justice Chandra Suman on confidentiality, your lordship will see. Very, very.
I was told notice.
Yes, my lord knows it.
Madhyamam something.
Yes. My lord, for immunities and privileges, that cannot be asked.
Against natural justice and open justice was being.
Yes. So, my lord, that is not, that test cannot be overcome by my learned friends. And specifically, your lordship kindly notice the redaction. My learned friends have come to court, says that I was not given any information to what they are looking at. But your lordship will kindly. But if your lordship permits me, my lord, I've made a small chart which will only show how many times information have been sought for and information have been given by learned friends branch. And why? Because the information that was provided was not good enough. But this is not primarily a judicial finding, my lord. It is more in the nature of an inquiry, your lordship will kindly appreciate. They are asking for documents. And they are supposed to give documents. You don't give documents, your lordship knows what is the consequence of 6, 7, 8. So, my lord, I will just hand over, my lord, this I have made, my lord, with the page numbers. I am also giving it. This is from the brief, only to show how many times, how many appendices were repeated, calling for information. But when there is so many repeated information sought for, they are giving information for it. That's the question of violation of natural justice arise. And you have come to court, you have yourself admitted the most important document you have said, I cannot show. It's the most important document, because that takes it otherwise into the hands of the authority. Otherwise, that would have been considered. One who refuses is not entitled to raise this question at all. And my last submission, the lordship will kindly notice submissions and even the writ petition proceeds on the basis of as if they have never been found to be guilty of any kind of anti-dumping. But for the financial year 21-22, they have themselves said in paragraph 3 of the writ petition that it was not proceeded with because injury could not be found. They simplicity, they suppressed that there was findings of dumping against them. They just very cleverly, they say there was no injury, therefore it was not proceeded against. So it is not as if my learned friend's client has always been very clean, coming forward with everything. Oh, sorry, no. I'll just give you a moment. I'll just give it up to the paragraph. Oh, sorry, this your lordship will find at page 152, volume 2, which is the finding also by the SESTAT for the earlier year. That's what I think. Para 3 minutes. And in their writ petition, paragraph 8, they make a statement issued its final finding observing that there did not exist a requirement for the imposition of anti-dumping duties on any. So that means that they were earlier found that there was anti-dumping, or else there was dumping. That is also their safeguard order. Has it come up? No, in para 21 it says, I have been always found to be of negative terms. Para 21. So these are material facts. You don't couch it in that fashion. This is a legitimate jurisdiction, Malak. The law will also consider that. And Malak, I have handed over the chart, Malak, and I give you Malak, those would be my submission. Just give me 1 minute, Malak. And the foreign entity, Malak, I think Mr. Salve has already dealt with that, Malak, whether he can proceed in a petition in here, Malak.
No, that was not argued by Mr. Sal. Mr. Basu had raised that.
And on the first day,
Article
I had also
19
raised that point, Malak, because your lordship will kindly find,
Article 19 point was raised by Mr. Basu.
and I am also raising that point, Malak, because Malak kindly finds, Malak, this is first of all the affirmation. It's a foreign entity. I do not know how he is saying it's true to knowledge where he is camping at the moment. He doesn't say that he was at the locale. I don't find any authorization. I don't know whether your lordship will get an authorization. I don't have it. Madam, will kindly look into this, Madam. I don't know whether the competency, and I didn't have the opportunity. If that competency is for a foreign state, Madam, then I don't know whether it's an apostille or not, Madam. But your lordship will kindly have a look into this. Because I am not favored with these documents. Generally, with your lordship file, Madam. Because here he has only said that he is by occupation service working for Kenat Equate Petrochemical Company. Because Malad Petrochemical Company, I'm not too sure whether it's the same as Equates who has come before your lordship. KSCC. So that means it's a foreign company. Sorry, Malad. He says he's from KSCC. So that's a foreign entity. And this is applicable for both this matter as well as Malad, the matter. Equate and switch. That time. Put a mental video, but otherwise, submit on. I can't, I absolutely agree, Mallet. The point of suppression, Mallet, is something which I just took new, but the others I didn't reply, Mallet. I only wanted to show this not on the grounds of, Mallet. I am saying whether your lordship will take cognizance of this and not proceed with the matter. Because Mallet is very well known, Mallet, in equitable jurisdiction, someone can show suppression, equitable jurisdiction is closed for that person. That is my subject. I'm sorry, Mr. I should have mentioned that to Mr. Khaitan. I understand he's taken some steps, but I'm sure Mr. Khaitan kindly do this.
No, I do not know whether it's suppression or not. My non-tender made an allegation from the bar for the first time.
No, I have shown from
no way that I can deal with it.
I've shown from their documentation. It's a document from their document.
That my client has done. I do not know. It's a matter of fact. It's not connected with this.
Not referring to any other documents. It is his petition somewhere I've shown. I have not referred to any other document. Then I leave it on your lordship. Your lordship finds that yes, it is something which can be found from the records.
I can get into it. If I had known what I would have gotten into it. I've actually sat down, and this is not on a point of Demeram Road. They are replying.
Lordship will, if your Lordship doesn't take it, well, I am just making the submission for the equitable part. But those are my charges. I'm very good. And I tender my apology to Mr. Kaizana. I should have put it notice earlier, but I'm sorry. But Malad, I was looking at it from the point of maintainability also. So that's why Malad, I made this submission.
You take the risk of living on your own.
No, not at all.
But only to the extent that some new decisions have been cited, and some new facts have been referred to. But an aspect of that cause of action, very importantly, they want the cause of action. It has been stated repeatedly, it comprises the bundle of facts which I need to prove to get the relief. Now, the bundle of facts would include the injury aspect. The entire concentration has been on the breach of duty. My allegation of breach of duty on the part of the authorities. But the breach of duty has a consequence. The injury. Now, we are dealing with the situation where if we look at the proceedings, there are proceedings under the Customs Act, Customs Tariff Act, for the purpose of imposition of anti-dumping duty. But the procedure is not laid down in the rules, the procedure to be followed. The object of this exercise is not to impose anti-dumping duty. Now, my client's complaint is that, if I can use that word, rather losing half-baked findings. Half-baked, I'm just using for the matter of language, that these findings which have been arrived at in a particular manner, they will be taken into account by the central government, and an anti-dumping duty will be imposed for 5 years. Now, so the injury is not the apprehension of injury. A decision which I had cited before, my lord, the case where the Supreme Court used to observe that a well-founded apprehension of injury gives rise to cause of action. So that part of the cause of action, the injury part, has really not been. The entire emphasis is on what has been my complaint as to what the authority has done, but not the result which will follow from that. So much has been said, in order to somehow non-suit me, as far as this court is concerned. But nobody wants to catch this bull by the horn. Because I had, of course, my lord has to see if my lord has jurisdiction, but I will not say that my lord will act without jurisdiction. But the cause of action has a restricted meaning, and it has a wider meaning. So the cause of action in a restricted sense is not the immediate action which has happened, which is natural justice violation. But not in the wider sense, if the bundle of facts which I need to prove, to get relief, I cannot stop by saying this is the breach. I have to progress further and show the apprehension of injury. In this case, the apprehension of injury. If I do not demonstrate that, therefore the place where the injury will take place, that court having jurisdiction over that territory would have jurisdiction. It may be different courts in India, different importers may import in different places, but not that. Now this dissociation of the restricting the cause of action just to that in my humble submission is not in accordance with law. If my lord will also see that Adani's case. Adani's case not be in paragraph 12, no, I have placed this one, not page 49. The last sentence was, one was the authorities were in Chennai, the passbook was to be endorsed in Chennai. But the Supreme Court is pleased to observe that the goods which will be imported will be at Chennai port. Therefore, not the injury also in that case was at the Chennai port because they were claiming certain credit. They would have used that credit to pay duty at the Chennai port. But that credit was denied. They filed the petition before the Honorable Gujarat High Court. So the court was pleased to hold that the ultimate effect on the business at Ahmedabad has nothing to do with the cause of action. Because even the importation part, the one was the action of the authorities, the other was the consequence, the injury part. That also was at Chennai only. So the ultimate effect on the business then was that that is not an integral part of the cause of action. That is in the last sentence of paragraph 12 at page 49, and the last sentence of paragraph 18 at page 51. The judgment of the Supreme Court, which was referred to by additional Solicitor General, the summit was in the same compilation. But emphasis was on the forum convening. That part is, of course, not I have addressed. But paragraph 20. In our opinion, the High Court ought not to have dismissed the applications of the appellant without considering the petition memo, which has no semblance of a case having been made out as to how part of cause of action arose within the territorial limits of the High Court, or without any pleading as to how any right has been affected within the territory of Sikkim. So the injury part, if the injury is within the territorial jurisdiction of the court, the court does have jurisdiction. That's leading in my case, not so much of emphasis on the earlier part of the restriction, but paragraph 41, the injury part is there. That is the apprehension of injury. Therefore, and I do not actually want to cite a new decision at this stage, but my lord will find that cause of action is restricted and wider. Supreme Court has dealt with it, and so a place where the effect is given. That is a place where part of the cause of action arises. My lord will find that that is the legal position because the injury. Now, I will just get my lord to this which I have cited, and which is one unanswered. I mentioned it. This, of course, this Adi Seva.
Yes,
2016. Paragraph 12. The third line at page 737. Yes. But page 77 of the third line, paragraph 12. Firstly, it is difficult to appreciate as to why the petitioner should be non-suited at the threshold merely because geodate has not been given effect by actual orders to them. The institution of a writ proceeding need not await actual prejudice and adverse effect and consequent. An apprehension of such harm, if the same is well-founded, can furnish a cause of action for moving the court. So, there again, the Supreme Court has said not the adverse effect and consequence. They on the other side want not the two to be divorced. They want the action of the authority not to be divorced from the consequence, not the effects. And but the consequence and the effect is not the imposition which will come because this order, the final findings have been arrived at under the framework of a law which provides for imposition of anti-dumping duty, and that aspect cannot be lost sight of. It is not a mere exercise. Look, it has been said that it is premature. When I can see on the face of it, that how the violation of natural justice has taken place, something has been used without disclosing it to me. And not if I can make a complaint of it now, because otherwise thereafter there will be a notification, and I'm stuck with an imposition which makes me which is going to cause me injury. So for 5 years, then I have to fight out how many years it will take for that course to run. So therefore, in my submission, I came at the right time because I could see the injury which will happen if this was if the government acted on the basis of these findings and that anti-dumping duty. And as I submitted, I was not against the whole of it. The entire there were so many people against whom the duties sought to be imposed. I was only on my, I argued only the aspect of natural justice, because that is not inviting my lord to go into the merits of the matter, and it was just so therefore the other pleadings which were shown, those arguments are not made. The entire emphasis has been on this. Therefore, the other part is regarding this redaction. Now, kindly take note. Rule 7, my lord will find that the authority is not in this compilation note, it is there. But first of all, if I may show under what authority this rule was made. Kindly take note. Page 5 of the compilation, section 9A starts at page 3 and at page 5. With the subsection 6. The margin of dumping as referred in subsection 1 of subsection 2 shall from time to time be ascertained by the central government after such inquiry as may consider necessary. The central government may, a notification in the official gazette, make rules for the purpose of this section. And without prejudice to the generality of the following sections may provide for the manner in which articles liable for any anti-dumping duty under this section may be identified, and for the manner in which the export price and normal value and the margin of dumping in relation to such articles may be determined, and the assessment and selection of such anti-dumping duty. The Parliament has conferred authority upon the central government to make these rules. Now, only the rules are made under this particular statutory authority, and the rules start at page 9 and rule 7 is not the confidential information part. But sub-rule one was at page 11.
Yes.
Notwithstanding anything contained in sub-rule 2, 3 and 7 of rule 6, sub-rule 2 of rule 12, sub-rule 4 of rule 15 and sub-rule 4 of rule 17, the copies of applications issued under sub-rule 1 or rule 5 or any other information provided to the designated authority on a confidential basis by any party in the course of investigation shall, upon the designated authority being satisfied at least confidentiality, be treated as such by it, and no such information shall be disclosed to any other party without specific authorization of the party providing such information. Some of the rules made by the central government under the authority granted by Parliament provide for this confidentiality. Now, what has been done in the writ petition is to preserve the same confidentiality and not beyond that. And my lord will find that in every paragraph, wherever the redactions are made, it is explained why the redaction is made. It is not that the redaction has been made just upon someone which is dictionary. It is explained. But kindly take, for example, one is the general explanation, paragraph 10 at page 7. But paragraph 10 was the 5th line. The petitioner states that in the proceedings before the respondent number 1, confidentiality of business sensitive information and documents is maintained, whereby the confidential information is provided only to respondent number 1, whereas a summarized and redacted version is circulated to the parties to the proceedings as a non-confidential filing. The petitioner states that the present petition, some confidential documents have been referred to but have been annexed with redactions to preserve confidentiality. The petitioner states that in the present petition, some confidential documents have been repeated. The petitioner says please to refer to and rely upon unredacted versions of these documents and other confidential documents at the time of hearing this application is finished. And what those documents were produced, they were made available not to the respondents numbers 1 and 2, because not they, the allegations, those allegations are to be answered by the respondents 1 and 2, respondents 3 and 4 have nothing to do with it. So it is not that that they had to answer something without knowing what they had to answer. So it's only the respondents 1 and 2 who were concerned. And what it is, they were quite similar. A lot has been said about the questionnaire which was sent and the query was redacted. But kindly have a look at paragraph 15 at page 11. So this is just an example there. The petitioner states that on 23rd May 2025, respondent one requested certain clarification, information, data regarding the cost verification response filed by a petitioner. As this request contains highly confidential and business proprietary information not susceptible to summarization, the petitioner has annexed this request in a redacted form. I have explained my conduct. It is not that I know it is not that I was shy of producing it before the honorable court, but I did. And the authorities also they had it. So therefore, this entire law, this anti-dumping law, it concerns commercial interests. So there can be no doubt about it. But the idea is to protect domestic industry, but then the commercial interests of the domestic industry. So therefore, with commercial interests are involvement, Parliament has framed the statute, given the power, those rules, the rules made in exercise of that power provide for confidentiality. What the respondents 3 and 4 did not have access to before the authorities, they cannot complain of not having access to that before the honorable court. And they are not required to meet that case. It's not that the judgment which was referred to by an understanding, the Al Ravino, the English judgment. If my lord is pleased to have a look. So this judgment has been referred in that Madhyamam. But I found a reference to it in paragraph 169 and 170. My lord has seen that decision in the other matter. In paragraph 169 and 170, at page 499. So that is at 2023 13 SCC 401. And there is specific reference at page 499, paragraph 169 and 170. I will kindly have a look at the system. Kindly see what was the controversy. But paragraph 1 at page 2. The issue that arises on this appeal is whether the court has the power to order a closed material procedure as described in the preliminary issue that was tried by Justice Silber for the whole or part of the trial of a civil claim for damages, and if so, in what circumstances it is appropriate to exercise the power. The preliminary issue was in these terms. Would it be lawful and proper for a court to order that a closed material procedure as defined below be adopted in a civil claim for damages? Definition of closed material procedure. Closed material procedure means a procedure in which the party is permitted to comply with his obligation for disclosure of documents and rely on pleadings and or written evidence and or oral evidence without disclosing such material to other parties, if and to the extent that disclosure to them would be contrary to the public interest, such withheld material being known as closed material. So this is not a civil claim for damages. Now, kindly see what was observed. Paragraph 12, and this was placed by counsel to the other side. Look at page 5. Secondly, trials are conducted on the basis of principles of natural justice. There are a number of times to this. A party has a right to know the case against him and the evidence on which it is based. My lord has seen that. Therefore, the case with regard to the principles of natural justice is that is why originally respondents 3 and 4 were not made parties. They wanted to be before my lord. And instead of joining into I have made the prayer that let them be added. But we are not to answer this case. Therefore, can you see what was held? I think that summarizes the view taken by the law lords. But paragraph 69, where Lord Dyson concluded his decision. There were 9 law lords on the bench, and the majority went with Lord Dyson's view. But paragraph 69 and page 21, not the 4th line. But for the reasons that I have given, I agree with the Court of Appeal that the issue of principles raised by the closed material procedure are so fundamental that a closed material procedure should only be introduced in ordinary civil litigation, including judicial review, if Parliament feels fit to do so. No doubt, if Parliament did decide on such a course, it would do so in a carefully defined way and would require detailed procedural rules to be made, such as Civil Procedure Rules, Part 76 and 79 to regulate the procedure. Now, in our case,
Parliament has decided.
And these rules are placed before the Parliament. So therefore, my complaint by a private party of something they've never had access to, and when the matter is relating to commercial interest. So this is that judgment. But both sides, or all sides, refer to paragraph 158 of the writ petition for the first time in their reply. However, paragraph 158 has been dealt with in the writ petition Not in ground 20 minute pages 37 to 41. It's not that anything is unanswered. It was said, Mr. Talve said unanswered. No, that he never said, he referred to 159 and 60 at the beginning. But if he had mentioned 158, I would have taken my lord through that answer to 158. It only speaks of the back and forth between me and the, and not, therefore it is not that it is unanswered, it is
The
there.
answer is that paragraph.
In ground 20 minute pages 37 to 41. Look that November 2025 import note, it was said that it is the facts are being created. Look that the order is placed by the customer here. That is not in my hand. And not 5,000 tons, not several crores of rupees. My lord will see from the bill of entry. It was several crores of rupees. It is not in my hand. If they want to buy, they will buy. Okay. So to say that somebody has created tax for the court to have jurisdiction, it's not a fair comment. Kindly look look, I'll just that one decision which I have to deal with, Mr. Salve cited was the Supreme Court decision in the Topsco case. So I'll take a little few minutes over that. I'm not, my lord, the officer is from,
Come back to
That supplementary affidavit method, Lord, it is, sir. Kindly have note page 4. Lord. It's the bill of entry. It is, Lordship. But kindly see that it's the bill of entry. But kindly see that against row B, declarant, importer name and address. Yes. It's IVL Dhanseri Petrochemical. So they are the importers. Yes. But top of that, on the right hand side, bill of entry date 16/11/2025. This is after the affirmation of the requisite. So it's not prior to that. So then the next page, against row A, invoice. Invoice number and date is 3rd November 2025. So the invoice is, the order date is given in my pleadings 13th October 13th October 2025. But the invoice is 3rd November. And look, the supplier's name, my lord, will find the petitioner's name is mentioned. And then you kindly see the last row. The goods are described, unit price, quantity of 5,000 odd metric tons. With the amount in dollars is 25,56,694. But the value in Indian rupees, accessible value is at the top left, 22 crores 89,49,769. So these are not something my buyer, and my buyer not actually his reputation was first. So this is the buyer note. They final findings had come, they would have thought it in the interest of their business to buy. If the duty comes, then it makes my goods more expensive. They have taken the decision. I have not had anything to do with that. It's just that the facts which had transpired prior to the formation of the requisition should have found place. It was not there. The bill of entry arrival and bill of entry is a subsequent factor. That is 16 million. There's no motive can be imputed to this particular document. Now, on this, I realized that the decision of our court, the division bench, which was cited before my lord on the cause of action, it's
a reiteration of Adani.
And the facts in that case, my lord will find the facts in paragraph 24, 25, and 26 as to why the court was pleased to hold that there is no territorial jurisdiction. But the facts pleaded were not integral to the part of the cause of action. And here the threat of the duty note is real. It is a well-founded threat note. Now that leaves me only one decision. The other would be what has been argued afresh by Grand Counsel for the Union. They were not here to listen to the arguments earlier. Therefore, they were arguing it as if they were arguing for the first time, but if they have been present to hear me, they possibly, because mine was a very limited argument. None of this judgment of the Honorable Supreme Court was in Aldet Chopso, it is in the compilation set 2.
Yes.
But it's at page 26 is where the judgment starts. The prior pages must be head note.
Yes.
With paragraph 4, the last 4 lines. During the course of the inquiry, the authority inter alia held that in spite of demand made by the respondent had failed to furnish the necessary information in regard to its exposed price of the said catalyst to other third countries, which failure, according to the authority, significantly impeded the investigation. Consequently, the authority determined the normal value of the concerned catalyst on the basis of best judgment assessment. So there was something which significantly impeded investigation, and then they did a best judgment assessment. My lord will find that when going to the judgment, I'll place the relevant portion, that what was the alternative basis adopted was disclosed. Unlike in our case. And my lord, there is a contest whether on principle that could be used or not. So it is not that best judgment means you can do what you like. So best judgment means that the basis is disclosed. And look, kindly then take note, paragraph note 7. But I don't need to place paragraph 7. Kindly take paragraph 8. The tribunal also held that since the anti-dumping duty is exporter specific or manufacturer, no, I think let me give that actual background, otherwise it will become a little unclear. So what they did was they took the normal price of other exporters, other country exporters. But the complaint was this particular importer took the stand, exporter took the stand that first of all they did not give the export price to third countries. Then they said, I've given you my cost of production. That other one I have not given you. Now you determine as per cost of production. So the tribunal held that the authority said that no, I will not go with your cost of production. I will go on the basis of the cost of production of other exporters from other countries. Tribunal said that no, it is exporter and manufacturer specific, so you cannot go into the data of somebody else and fix the normal value of this particular exporter. So therefore, that is wrong. The Supreme Court was in that background. The Supreme Court said that you will not give your data and tie down the authority to something that you have given. Then the authority is not bound to proceed on the basis of that. They can reject what you have given and move to the alternate basis. And that particular basis, there was a debate whether that basis could be adopted or not. And the court held that the court was pleased to they reversed the order of the tribunal to say that this is the proper basis. Not the can you see the now paragraph 8. The tribunal also held that since the anti-dumping duty is exporter specific or manufacturer specific, the price of similar article manufactured by some other exporter manufacturer cannot be the basis for finding out the normal value. Applying the above options, the tribunal came to the conclusion that since the respondent did not have any domestic market for the subject catalyst in Denmark, and there being no material to establish the respondent's export price of these articles to appropriate third countries, the only basis to determine the dumping duty, if any, would be the manufacturer's cost of production in its country of origin. So, one was not there. First criteria. Second was not given. Third, they said this is the only basis now available. Now, a kind of a helplessness was expressed by the tribunal because they thought that was the law. Now, kindly see paragraph 11 at page 28. On behalf of the appellant, it is contended before us that the authority was justified in relying on the comparable export price of another exporter in the background of the fact that the respondent was withholding the most relevant evidence and in a way compelling the authority to proceed with the determination of the normal value based on the selective evidence produced by it. The respondent supported the order of the tribunal by contending that its cost of production of the subject catalyst was sufficient material as contemplated by the statute itself. Therefore, the authority was not justified in placing reliance on the export price of third parties while determining the normal value of the subject catalyst. In the instant case, the authority proceeded on the presumption that it had no obligation to accept or force the material submitted by the respondent to establish the normal value of the article concerned, more so in the background of the fact that the respondent has not furnished the information pertaining to its export price of the said catalyst to an appropriate third country. In this background, it referred to determine the normal value on the basis of what it held to be a comparable price of other exporters. In a way, drew adverse influence against the respondent for not producing its export price of the subject catalyst. The tribunal, on the contrary, came to the conclusion that since anti-dumping duty is exporter-specific or manufacturer-specific, the price of similar articles manufactured by other exporters manufacturers cannot be the basis for finding out the normal value. Then what paragraph 13, what the court was free to set out section 9A 1C note. If I'm just show note quickly, the material part normal value in relation to an article means the comparable price in the ordinary course of trade for the like article when meant for consumption in the exporting country or territory, as determined in accordance with the rules made under subsection 6. So, in the exporting country itself, the price at which it is sold. Then, 2. When there are no sales of the like articles in the ordinary course of trade in the domestic market of the exporting country or territory, or when because the particular market situation or low volume of the sales in the domestic market of the exporting country or territory, such sales do not permit a proper comparison, the normal value shall be either A. Comparable representative price of the like article when exported from the exporting country or territory, or an appropriate third country as mentioned, as determined in accordance with the rules made under subsection 6. So, this was the statutory requirement step by step. So, the next thing was that if there is no domestic market, then third country exports. Now, this was withheld. Then the last was cost of production. The cost of production of said article in the country of origin along with reasonable addition for administration. So this was the, so then what in this background note, kindly take now paragraph 14, was little below the middle. The question therefore for our consideration is whether an investigating authority has any discretion to reject the material produced by one of the parties to the proceeding in regard to the alternative enumerated in section 9A, 1C, II, A and B, and prefer any other material to establish the normal value. As noted above, the authority proceeded on the basis that it had the discretion to reject the evidence produced by the respondent. Tribunal held that the authority had no such discretion in view of the fact that anti-dumping duties exporter specific. It would be appropriate at this stage to extract the actual wording of the tribunal in regard to this finding. Since anti-dumping duty is exporter specific or manufacturer specific, price of similar article manufactured by other exporters manufacturers cannot be the basis for finding out the normal value. With respect, we are unable to accept this finding of the tribunal. From a careful reading of section 9 of the Tariff Act and rule 6 of the rules, it is clear the statute has nowhere put such a restriction on the investigating authorities. On the contrary, a perusal of the said provision clearly shows that the normal value will have to be determined with reference to the comparable price. The word comparable price in the context can only be with reference to the price of similar articles sold under similar circumstances, irrespective of the manufacturer. By holding anti-dumping duty to the exporter specific, the tribunal could not have restricted the scope of the investigation only to the materials to be produced by a party against whom an investigation is being conducted. Such an interpretation of the statute is wholly contrary to the very scheme of the statute. It is to be noticed that the statute has given much wider power to the investigating authority than what is understood by the tribunal, which is evident from the language of section 9A 1CI of the Tariff Act and Rule 68 of the rules. As noticed here above, Rule 68 of the rules specifically empowers the authority to record its findings on the basis of facts available to it in cases where an interested party refuses access to or otherwise does not provide the necessary information to it. That apart, the use of the word sale of like articles and comparable representative price of like articles in section 9A 1C referred to herein above also indicates that the statute intended that while determining the normal value, the authority has the discretion to rely on such material as is available before it, which reflects the comparable value of the articles concerned, meaning thereby that the authority is not bound to look into the material which is produced by the interested party. Therefore, any argument which restricts the discretion of the authority in the area of appreciation of evidence on the ground that the anti-dumping duties manufacture specific will have to be rejected. But this is the last part. In the instant case, the authority has come to the specific conclusion that the respondent has preferred not to disclose the details of its export price or the concerned catalyst to an appropriate third country, even though the same was available with the respondent. It has also noted that the reasons advanced by the respondent for not furnishing the information are not worthy of acceptance. The authority has further observed that by withholding the necessary information which the respondent was bound to have disclosed under the statute, the respondent has not cooperated with the investigation and has caused impediments in determination of the normal value. In these circumstances, we are of the opinion that the authority was justified in proceeding to determine the normal value of the subject catalyst on the basis of best judgment assessment. But the findings are not there in our case. When I had placed before my lord the letter which was written saying that please see it online, please see it on site. That but there was good reason, but the alternate basis I submitted that was before that was debated. We do not know here as to what that material is, why it has been used. I don't think that I can add much more.
Only one thing, Chetan, it was touched upon this last time that we being a foreign entity, Article 19(1)(g) may not be.
Article 19(1)(g) is not clear. Article 14 is that the equal protection of the laws. That Article 14 is available, and that is the only article. 19(1)(g) that cannot.
That is not the practice of this code. I just would want to, with your lordship's permission, reiterate two submissions. Which is, my lord, the first is on the injury part. So, my lord, the injury or the potential or the alleged injury, my lord, is not put my learned senior friend. It is to his potential customers, as my learned senior friend submitted, who may not or may buy from him in the future.
This was submitted.
And my lord, on the second point, which is confidentiality, the redaction, the rule 7 with my learned senior friend place, the confidentiality is with the authorities.
This was also submitted. Mr. Salary on the what it is.
You want to reiterate and this is all.
These are the points were covered by Mr. Salary on the last period. He said that he is not an importer, he is an exporter. We will export only if somebody is ready to import. This is what he began with last pillar.
And not even, in fact, the bill of entry which my learned senior friend placed, the order has been placed upon him for the first time in the last 4 years. Since 2021, no orders have been placed upon him by that concerned buyer.
Where do I get that?
My lord, if you come to page 103 of my compilation.
But in paragraph 41, it is mentioned that 21-22, 19,000 odd metric tons were exported. No further data was given, and this was the import thereof. But this period falls within the period of under investigation, and this is it's an ongoing business to demonstrate that as I submitted 22 so many crores worth. This is not a game that anyone plays it like this with.
On the point of maintainability, I am concluding here.
Lordship.
Both the matters. Both of them. Because alada alada. 1 and 2 बोल रहे हैं ना. 1 and 2 alada alada order. Heard the learned additional Solicitor General, assisted by Mr. Tiwari, learned senior advocate, appearing for the Union of India. Mr. Uday, learned advocate, appearing for the respondent number 3. And Mr. Chetan, Mr. Alan Senior, appearing for the respondent number 2. And Mr. Chetan, learned senior advocate, appearing for the petitioner. hearing of this petition is concluded on the point of maintainability of the petition. Full stop. Reserved for orders. Full stop. Restraint limit. Two copy orders to do Mr. Satyananda, Mr. Rajiv. Mr. Raju, you are adopting the submissions of Mr. Prasad. His submissions will go in your name in the second. And Mr. Salve's submissions were already concluded.
Both 1 and 2, 1 and 4, and this one and 3 is the right for 1 and 2. Look, my recording has actually under next.
Very good. Assisted by Mr. Kumar, Mr. Kundalia, as well as Mr. Kundalia. That is still appearing for Union of India. Apni given and encouraging. And Mr. Salve is for 4.
Respondent 4 is both 1 and 2.
Yes, yes, that was the, I said that we have concluded it on the last occasion only, so his name is not being recorded today. Yes, yes, if we accept. Reserve, judgment reserve. On the point of maintainability. And petition below as follows. Petition গুলো একসঙ্গে করে দিন, সাজিয়ে দেবেন।
Yeah.
দিদি এটা একটা ফাইল করুন, রেসপন্ডেন্টদের আলাদা করে রাখবেন, একসঙ্গে ইয়ে করবেন। সাইটেশন বাই রেসপন্ডেন্ট করে ওখানে ঢুকিয়ে দিন। পুরো সাইটেশন বাই পেটিশনার লিখে আলাদা আলাদা করে রাখবেন, মানে আমার অসুবিধা হয়ে যেত। এটা রেসপন্ডেন্টের আলাদা ফাইল আছে, এখানে ঢুকিয়ে দিন।
Mentioning? No, no, not mentioning. My junior friend had mentioned item number 599. In the morning, my lord had said that notice is to be served upon the respondent. So my senior friend is here for the respondent because that today is fixed for demolition.
For demolition. Very well.
Anytime, my lord, because my
I'll just call the list. Please be here.
I'm very grateful.
Item number 17 of today's list. What is the urgency? Well, it can be taken up on Monday, not a problem. Monday ওটা urgent দিয়ে দিই।
Well, Lordship is aware, my lord, there was this entry tax which was introduced by the state government. Now, my lord, the virus of the tax was challenged, that provision was challenged, and my lord, it was set aside, the single bench of this court, my lord, set aside that. Then, my lord, ultimately, my lord, in appeal, my lord, that was again overruled. It was restored. I mean, the single bench order was, my lord, set aside. Now, the petitioner is a special economic zone inhabitant, SEZ company. Now, in terms of the statute, and that is, my lord, this is the benefit which the state government only grants to an SEZ. In terms of the statute, if you set up an unit in the SEZ, you are free from levy of any taxes whatsoever. And the SEZ as a legal proposition is not, it's treated as a foreign entity, as if the goods are being manufactured in a foreign place and not foreign territory. That's what they say. Now, this being the position, our stand had been that because I am a SEZ unit, I am not affected by the entry tax, doesn't affect me at all. But good, bad, indifferent, my lord, after the introduction of entry tax, they had made a demand. But because, my lord, it was set aside, my lord, I was not affected. But post the division bench order, my lord, setting aside the single judge judgment, my lord, I got affected. So, my lord, I initially joined, and an appeal, and SLP was preferred in the Supreme Court. So, I initially joined them over there. And then, my lord, I withdrew from that, my lord, being added as a party, and I filed a separate also, that separate, that I am a SEZ, I am not bound by this at all. Now, my lord, in the meantime, what has happened is, and that is pending, my lord, we have stated that is pending. Now, whatever be the outcome of my SLP, the state government has now come up with a special scheme where, my lord, it is offering a discount of substantial percentage, 75%. 75% upfront payment, and, my lord, your liability goes. No penalty, no interest, nothing. They have come up with a scheme. The scheme is expiring on 31st of December. So, my lord, what we did is, and, my lord, even from the, my lord, I won't say officers, but even there is a view amongst the persons dealing in the government also that perhaps SEZ doesn't fall in this. So, my lord, we made a representation to the state government that you see that it is pursuant to your representation as a SEZ, I have set up my unit. If I am a foreign territory and entry tax doesn't affect me, then kindly clarify, because if the state clarifies entry tax, at the end of the day that I am doing business in the state, then, my lord, I don't have to face any harassment. But if the state says that no, you are liable to pay, then, my lord, without prejudice, I can take advantage of the scheme and I put in the money 75% or whatever without prejudice, my lord, either in court or otherwise. And, my lord, I can get advantage of the scheme, because if, my lord, 2 years down the line or 3 years down the line, my lord, it is held that no, I am liable in spite of being an SEZ, I lose the benefit of the scheme. That is why, my lord, this representation is necessary. Yes, my lord, kindly come to page 422, that, my lord, lordship will find in the list of dates, item 14. My lord, in the list of date, what I have submitted so far, my lord, all the particulars have been just put in black and white. That's all. Page 422.
Page 422.
This is annexure P5.
Yes.
So this is a representation of 13th October made to the additional chief secretary. Kindly see the subject, entry tax exemption on special economic zone units. We sincerely thank the government of West Bengal for its continued commitment towards creating a progressive and business-friendly so-and-so, though visionary leadership, strong policy so-and-so. The government's focus on ease of doing business, MSMEs attract significant investment. We appreciate the government's protection. This is what the government has done. Kindly come to the 4th paragraph. We would like to bring to the knowledge of your good self that with the objective to facilitate the development operations, maintenance, management, administration and regulation of special economic zone in West Bengal and accelerate economic reforms to promote the rapid and orderly growth, development and operation of the industries, the West Bengal Special Economic Zone Act 2003 was notified. We have set up solar module. My clients are Vikram Solar. They have set up a solar module pursuant to this at the SEZ, and this is undisputed. We have set up a solar module manufacturing facility at the Falta Special Economic Zone, operating since 2009 with current installed capacity of 3.2 gigawatt. We would like to bring the following to your kind attention. Then section 27 is the section which is paraphrased, which provides for exemption from taxes, duties, levies and cess payable under the provisions of West Bengal state law for any goods exported out of or imported into a special economic zone. Similarly, with an objective to provide for establishment of development and management of the special zone, promotion of export, center notified the Special Economic Zone Act. So, my lord, there are both the State Act and the Central Act, which is giving the same benefit, that so far as any state taxations, I am getting protected, central taxations, I am getting protected. Then, my lord, kindly straight away come to page 423.
Yes.
In sync with the aforesaid provision, sale of goods by a dealer to SEZ unit was made exempt under section so and so of the West Bengal VAT. This is, my lord, prior to the GST era. West Bengal VAT Act under the West Bengal VAT laws. Further, inter-sale goods by a dealer on an SEZ was also exempted in terms of section so and so of the Central Sales Tax. With the policy initiative and support of the government and to become pioneer, we made substantial investments and set up solar photovoltaic module manufacturing unit at Falta in the year 2009. We were availing of the tax concessions, exemptions provided by the state and central government on the goods service. The government notified West Bengal Entry Tax Act 2012. Well, we are concerned from 2012 to 2017, because 2017, my lord, GST came and all, that is separate. That we are not. 2012 to 2017. So, my lord, after entry tax, my lord, kindly see the next para. We were not paying entry tax on goods imported from outside the state on the premise that we were operating as an SEZ unit and were immune from payment on account of exemption conferred by the SEZ Act. We would like to submit, we interpret that no entry tax is payable in SEZ for reasons mentioned below. Well, we have mentioned the sections. Kindly also note that the state laws, well, after that, kindly also note the state laws and SEZ policies of various states, namely Odisha, Kerala, Madhya Pradesh, Tamil Nadu, specifically provide for entry tax exemption on goods imported by an SEZ unit. Although the intent of the law is very clear, not to charge any kind of tax on the supply of goods to an SEZ.
But
unit.
Mr. Chaudhary, at page 424,
Yes.
Is not the same issue before the Honorable Supreme Court at large?
No, my lord, before the Supreme Court is the virus of that. Now, if the Entry Tax Act is upheld or it is, my lord, struck down. My lord, if
the first paragraph at page 424
yes,
is suggestive of something like that. If you read the
part of the
yes, my lord, I am only asking, my lord, today, if I suppose I win in Supreme Court or I lose in Supreme Court, my lord, this is because of the scheme that they have taken out. Today, my lord, if after 5 years, my lord, even if I lose, so my lord, I want them to take a stand. My lord, the state has an independent stand, because my case is, my lord, if VAT is struck, if the entry tax is struck down, then lock, stock, barrel, everything goes.
No, but your challenge before the Supreme Court is that you are not liable to pay tax because of you being an entity in the SEZ. This is the purport of this.
No, but my lord, this is, my lord, Supreme Court is not deciding. I am, my lord, Supreme Court is not deciding on my, if I am held liable, my lord, whether I am entitled to the benefit under the scheme or not.
But
This entire, my lord, I just clarify. I understand what is falling from your lordship. My lord, kindly visualize. Suppose in this, why this writ petition and why this representation? Suppose in the Supreme Court upholds the order of the division bench and negates my contention that I am not a SEZ. Then I become liable. By that time, the scheme would go. So I have said the state government itself, my lord, because my lord, all these concessions are given by the state government. If the state government today takes a stand that no, SEZ is exempted, I don't have to go through the rigmarole of Supreme Court and face the uncertainty. Conversely, if the state government takes a stand that no, in spite of being a SEZ, you have to pay entry tax, well, at least I get benefit of the scheme and I put in that, well, without prejudice.
But is it not so that state has already taken a stand?
No,
That is why you are
no,
going
no,
to
no,
Supreme
no,
Court?
no. Well, state has not taken a stand vis-a-vis SEZ. Well, I am obliged, Lordship, ask this question. That is why, my lord, that is why this representation. And that is the stand, my lord, I am asking the state to take. Because in all those cases, not a single case of SEZ is involved. It's the virus of the act. It's the virus of the act, whether it is constitutional or unconstitutional.
Virus of the Entry Tax Act.
Entry Tax Act. My lord, Article 304 is involved, whether it is discriminatory that you are charging.
So this question is not.
Is not there. Is not there.
As to whether.
My lord, in the writ petition.
By dint of
Correct.
being an
Because, my lord,
SEZ tax will be leviable.
Correct, correct.
Not
Because, my lord, the important question that lordship it just now fell from your lordship, has the state government, if state government has taken a stand over there, and my learned friend will, my lord, contradict me if I am wrong, state government is not required to take a stand in the Supreme Court or in all the other proceedings vis-a-vis an SEZ. They were not required. But we have been caught in this because of the entry tax and because of this. That is why we are asking the state government to take a stand. Because, my lord, two things will happen. If the state government takes a stand, then, my lord, my further investments in the project also and, my lord, other plans will also, my lord, I will plan.
Where is the scheme?
Let me have copy. দেবো নাকি তোমার দিচ্ছে না স্টেট
If you want to take benefit of the scheme, one.
Yes, yes. My lord, kindly see, my lord, internal page 3 of 7. My lord, kindly see B. Any area tax penalty late interest as defined in 2(1)(a) relating to entry tax. Area entry tax is 75% of area tax in dispute. That's all. So, my lord, I want to, because, my lord, photovoltaic cells, solar cells, my lord, this is a unique industry which is, my lord, heavily, my lord, it involves a lot of investment. Now, I have already made substantial investment based on certain representations of the state. Now, neither do I want to be a defaulter so far as that is concerned. My lord, this representation is important to me for two things. My lord, I know where I stand, that if they say today you are liable to pay entry tax, notwithstanding SEZ, then I know that I take a commercial call whether I should make any investment here or I should remove my project and go. That is one aspect. And the second aspect is, my lord, if they say it is not payable, then, my lord, I will just take that stand and I withdraw my Supreme Court. The Supreme Court becomes infructuous. I am not affected by that. I can give that undertaking.
Yes, Mr. Choudhary.
And, my lord, only thing I am praying is that they should dispose of the representation taking a stand at least within 21st or 22nd, so that I get time to, if I have to comply by 31st or extend the timeline. It shouldn't be, my lord, that
Be extended for 1 month.
I am not saying, then take the decision. My lord,
There's no question of taking a decision. Kindly come to page
5(9).
5(9). Kindly come.
or if my learned friend has the instruction today that I don't get the benefit, he can.
This issue is pending before this.
No.
I'll show their pleadings, well, what is the issue pending? Kindly page 59, last paragraph. Well, this is the essential synopsis. Well, the petitioner has referred several applications being to also petitioner of this belief. After challenging the assessment order, confirming the demand of the impact or impact of can understand. Last paragraph. The assessment orders are under challenge. So the moment the assessment orders are challenged, the result consequences is that the issue of impact will be considered. Assessment orders confirming the demand for impact for on the ground for the unconstitutional, and that means even the physical whose living resident would not be liable to be that whatsoever. But this is their own case, so this is their own finances. So they want to ask to take a decision where they have gone to the or a kind of order for state post. I no question. When the assessment orders are under challenge, the moment assessment orders are under challenge, but the difficult consequences that I have to decide on that issue. And then the last line, final highest respect for my other last, kind of the last three lines. If you are the appropriate submission, shall not be payable or before procurement of by a salesman. Outcome awaiting a maximum by a court ask enact or a
No, that won't be the direction.
ask for a ask for that letter for that. And it is not only the conflict. His characteristics also understood. But according to him, but I am not putting my content before that. This is their own film and reliable. This is their own items they have finds over the honorable. And this is their own application which was filed with the tribunal challenging the assessment order. That's
Well, in the assessment orders and in the orders, my lord, two orders are before the Supreme Court. One is, my lord, the order of the division bench, and another is the order of the taxation tribunal, where portions were held to be ultra vires. Twofold. Let my learned friend show that in either of the orders, my lord, the position of SEZ has been decided this way or that way. Correct. My lord, if the entry tax, my lord, if the virus of the entry tax had gone, Milord, I am not affected either way. And in both the cases, Milord, I cannot have a shifting stand. I cannot say there that I am admitting or not admitting and I come here and take. I have to take a stand that either way, I am not affected by entry tax. Whatever stand I have taken, I am taking it here also. Whether entry tax is...
But how will the authorities then prejudge
No, no.
that? If we have
So far,
already raised this question before the
no, not a question of prejudging, madam. The authorities have to take a stand. This is the state authority. According to this, they are not conceding to that. Either, my lord, if they say,
they'll dispose of this application.
yes, my lord, they can reject my application. My lord, I know.
How can I go into the merits of the issue?
You will say that it is pending. I will
say sub judice.
No, my lord, sub judice, my lord. Then it is, my lord. This is the problem, my lord. This is the problem, my lord, why investors are running from this state. My lord, kindly see, my lord. Kindly see, my lord. All I am asking the state is that take a stand whether I am to pay more tax or you are recognizing me as an SEZ. Lord, they will not take a stand. I am not saying I will not pay the tax. All I am saying is, as per your scheme, I will put in 75%. So the stand is, I am not going to decide anything. And my lord, how, my lord, with respect, again I am saying, all that I have said in Supreme Court is, my lord, I admit, I have said in Supreme Court, I am an SEZ. I am not affected by this. I cannot take a contrary stand in Supreme Court. I have taken that.
But by passing the assessment orders, they have already held you liable to pay tax, isn't it? Once an
My lord,
assessment order
that
is
is
passed
that
against you,
that was the old order which was passed. Now the stand is different. If my learned friend today takes a stand before your lordship I adopt the same stand of that. My lord, dismiss the writ petition.
Why don't you come with instructions on this? Because then these things.
But I tell you, well, that was challenged before the division, right? But kindly, I did not place it. I was not there. Kindly see stand.
My lord, I was not a party before the division bench. They did not make me a party.
Mr. Chakravarti, why don't you come with instructions?
Yes, let
on
him
this
come.
and it's over then. I'll record that. It will be
What
finished.
instruction?
Whatever instructions are there.
Whether I am liable or not liable, my lord.
That question is today. I cannot decide because the issue is pending before the honorable.
Bring that. Let us have it. Yes, bring
Pending before.
13th October 2025. What is the decision of the authority? That the court is entitled to know. On the representation made by them.
But assessment order, I am not disappointed. Assessment orders are understanding. The moment I take it, it directly affects the outcome of the result. If I say, can you consider this factor? Like today, our litigant has gone to the matrix application. But there is a scheme coming on the 31st December. This scheme is floating for a long time. People exchange the money to find this scheme that has to hand it over. Last date was September. Then it was exchanged. But everyone knows just
Yes, Mr. Chaudhary, that also is the point. Why didn't you approach the Supreme Court?
My lord, I have the prayer. My lord, what are these assessment orders? I'll tell your lordship. My lord, when the matter was initially challenged before the honorable single bench, my lord, by virtue of that order being set aside, the earlier orders had revived. So, my lord, that time the assessment was made lock, stock, and barrel. That SEZ point was also not considered by the state. My lord, they issued demands, lock, stock, and barrel on everything. Now, my lord, I would, my lord, just lordship will dismiss the writ petition if my learned friend can show that any of the fora below, whose, my lord, orders are before the Supreme Court, has decided this issue. Then my learned friend has. After that, because this was pending, all I have asked for is that don't revive the earlier orders. Don't take coercive step in respect of the earlier orders till such time this is pending. Because, my lord, the virus, that is vis-a-vis the virus. Because, my lord, at that point of time, my lord, nobody, no state authority, my lord, even thought upon or dwelled upon whether SEZ units are covered or not covered. This decision has not been taken at the state authority level at any stage. If my learned friend can show that no, 1 minute please, I did not interrupt you. If my learned friend can show that this decision was taken in 2017 or 2016, well, throw me out. The lordship will not find any decision that SEZ is also liable for entry tax by the state authorities. That is what I am asking them to decide.
61 last paragraph. Their SLP kindly see, this is the issue. They are agreed because their issue of SEZ was not considered by the division bench. Well, today, my learned senior friend is coming and saying that issue to be decided by the state authority, which is pending before Supreme Court. What time will decide?
Supreme Court will decide the virus of the act. 1 minute, please.
This point also is asked before the Supreme Court. Mr. Chaudhary, you have heard this point that in any event, because of being an
Correct. I am not liable. I have to say that.
So this point is also there.
Yes, I am not saying it is not there.
Then why unnecessary?
Well, at this point,
should this court then intervene? You could have approached the Supreme Court by filing an appropriate IA.
No, 1 minute. Well, consequential relief of the Supreme Court prayer is, well, in Supreme Court, I am asking for twofold relief. One is, my lord, the interim relief is in the nature of not to have a coercive step till that is there. And the alternate relief is that if I am an SEZ, either way, I don't have to pay.
Mr. Chakravarti, take instructions and come on Monday.
But I have taken instruction. By very instruction, the issue is pending.
You bring that instruction, I'll take it and then I shall pass it. Apply my mind on this. Can't be that easy. Take instructions. You should have said that then.
The state benefits. If they take the stand, I am liable, my lord, they get money. I don't know why this stand is being taken.
Question of money, whether someone wants to avail the scheme or not, it is his own choice. There are many consumers like Tata, we have gone and find the SLP there.
None of them are SEZ. Sorry, none of them are SEZs. Show me a single SEZ who has done it.
But this reputation, according to me, is not vendor on the face of it. But absolutely not. What happened was Honorable Single Judge had passed an order saying the ultra-violet declaring it is ultra-violet. Division bench stated you continue with the assessment, but do not recover anything. You continue. There was a specific division bench order. Thereafter, the issue went up to the tribunal. Tribunal passed an order.
So after that, my lord, these demands have again revived. And the coercive step is only with respect.
These assessment orders, nothing can be made out.
But this is
What was-
state. Supreme Court has stayed this. Well, if today when no
Well,
coercive action is taken, well, these orders are under scrutiny. Well, these orders are under scrutiny. Can I sit on appeal? Well, they are asking me to sit.
Very
on appeal
well.
of
Come
this.
back on Monday. I will also go through this.
Well,
I will take up
Very
my
well.
mind.
Very well.
Heard Mr. Chaudhary, learned senior. ওনাদের ওই একটা আর্জেন্ট বলছিল ডেমোলিশন আছে
Very good.
Yes, what is the problem? Who is demolishing?
Order of demolition has been passed. I could not appeal. It was passed ex parte in my absence. I have been suffering a chronic illness, Lordship, since 2016. Lordship, the plot of land in which, with regard to which the demolition order has been passed is a.
But is it not appealable before the appellate authority?
Appellate authority is not there, Lordship. It is.
It's an order passed under?
Order passed under.
West
Lordship,
Bengal.
Recovery of government property.
It is.
Madam, may I make a small submission before my learned friend starts? Learned friend is running a hotel in a plot of land at Salt Lake.
দেখি দিদি ফাইলটা Yes.
The plot number allotted to the petitioner is DD19, which is adjacent to two more plots. One is DD22, one is DD9. Notice was served to them in June. Prior to that, in 2024, another notice was served, in which they replied through their learned lawyer. Through that letter, they themselves admitted that plot number DD9 is not our plot. It has not been allotted to us. We are not the lessee or assignee of the said plot. We are using the said. And we will hand over and give vacant possession to the authority or any lessee or assignee whenever the authority wants. This their admission in 2024. Now, there are some slum dwellers in that plot, DD9. They moved a writ petition. That's pending before this honorable court. Now, my lord, during this period, the Joint Secretary of the Government of West Bengal, they issued a notice for recovery of vacant government lands which is lying within the Salt Lake area. During this process, fresh notice was issued to them. The petitioners never attended any of the hearings. Any of the hearings. In this case, while filing this writ petition, the petitioner number 1 is the father, the petitioner number 2 is the son, who is affirming this affidavit in this writ petition. The father may be ill. All medical reports of the father is enclosed in the writ petition. None approached. Not a single document produced before the authority. Authorities conducted survey, prepared report, submitted before the SDO. SDO, as the SDM, passed an order. Pre that order, no steps have been taken by them. Subsequently, they are coming up.
It's an order under West Bengal Public Land Eviction of Unauthorized Occupants Act.
Yes.
There is an appeal provision before the DM.
There is, Lordship, but there is no appellate court. It is under the Barasat jurisdiction.
You don't have a DM there?
No. It is
The DM is not taking up.
DM is not taking up these matters. That is why, Lordship, we have.
Why will he not take up?
Lordship, I inquired, I had sent.
No, he has to take up. It says he is the appellate authority. How can he refuse to take those matters? You have to file an appeal.
If my
Prefer an appeal.
Now, one more thing, my lord, the stand taken by them presently is that an unallotted plot has been bequeathed to them by an so-called lessee who has not been allotted by virtue of a will, which has been subsequently
given in
applied for probate on 11 November when the order was passed.
Very well, but those are all on merits.
But these were not produced before the authority, never.
Why did you not come to the court immediately then? The order is of 10th of September or something, I think.
11th
the
of
first
September,
offer.
thereafter, Lordship, on 14th of October, Lordship, we were served with another order of demolition. Kindly takes up page 21 of my lord's plea.
Page 21.
This is the second order. Lordship, kindly sees the bold portion. My learned senior friend has indicated to my lord what are the brief facts. I do not differ from that. Lordship, the next date for physical possession of suit number plot DD9 Salt Lake is 18th of December at 12:30. That is on this day. Lordship, it is also an admitted fact that my client, the first petitioner, Lordship, he has been chronically ill since 2016. Lordship, thereafter, Lordship, when he came to learn of this particular notice that was served upon him, this order passed by the subdivisional magistrate, Lordship, he waited for some time if he could recover and come into this court to affirm the petition himself. He could not. Thereafter, Lordship, through his son, he got a power of attorney. Lordship, he has filed this petition now. So, Lordship, my only predicament is, Lordship, the allotment. My allotted land is plot number DD19, which is a contiguous plot to DD9. Lordship, on DD19, Lordship, I run a hotel. Lordship, with regard to plot number DD9, it originally belonged to one Soumendra Hajra, who, Lordship, has made a will in favor of the wife of the petitioner number 1. Lordship, if there is a default on my part, I have not applied for probate at an earlier date. Lordship, after coming to know of this order, Lordship, I have since applied for the probate. Now, Lordship, the only predicament is that if I get a probate with regard to this plot, Lordship, and it is demolished earlier, Lordship, I stand to suffer losses. Lordship, what I would have prayed for, Lordship, subject to my Lord's kind sanction, Lordship, I may be given an opportunity of producing these documents before the authority. I admit that I have not appeared on previous dates, and I have annexed enough documents, Lordship, to show that since 2016 I have been unwell with chronic kidney disease and all those things. I have undergone operations and all. So, Lordship, my
And
only
when was this order dated 11th of September 2025 served?
no, it was served. I shall not say that it was not served. It was served upon me. This is my document. I have produced it thereafter. Lordship, I admit that.
What was the kind of illness that you were suffering?
Lordship will kindly take up. Lordship, all the documents that are appearing under as annexure, Lordship.
Kidney disease.
Annexure P5.
Gallbladder.
I
Lordship,
can find graft kidney written somewhere.
this is of 2025. If my Lord kindly takes up page 29.
Page
29. This is of 2025 of the 1st of November, 1st of September. And Lordship kindly takes up the last page, that is at page 88, if my Lord kindly goes to.
Yes.
This is of 2019, Lordship. There are also documents of 2000, medical reports of 2018, Lordship. It kindly takes up page 69, Lordship, 68, 69, Lordship. These are of the year 2018. So, Lordship, I have been suffering for long. Lordship, my only prayer would have been that, Lordship, I may be given an opportunity, let the authority decide, Lordship. Lordship, page 29 to 89, 60 pages of medical report. I do not want to burden Lordship with that.
Let them hear and pass the same order once again if they
One
want.
more thing. One more thing. This is an unallotted plot, not allotted by the government of West Bengal.
I'm not going on merits at all. Since he has not been able to represent his case because
my
of
lord,
its.
may I hand over this letter only?
Yes.
It's a bit marked, my lord, I may be excused.
Yes, not a problem.
Because this is their lawyer's letter. I will, my lord, just draw your kind attention, paragraph 10 and 11. Their reply. No story of any documentations.
আমি পাইনি।
What is the meaning of paragraph 11? See this. You have this document. This is not annexed to the writ petition.
We have initiated proceedings only thereafter.
This is a damaging document.
But I was not there. The language is very clear. I shall
Yes.
not. And let the state rely on this before the authority.
Rely.
And let just one
Where is this in the order? It has been written.
It does not find place in the order. I don't think so.
In the order, it is not there.
No.
This document is not there in the order.
Document, they have considered all documents. It is
Yes,
there. They have
but-
considered all documents.
But whether this was there or not,
No
it is not.
specifications, because there were sketch
I'll-
maps, there were
I'll-
sketch maps and all that.
Where is your ground that you have been ill? Paragraph 7.
My lord, paragraph 7.
Paragraph 6.
7, lord.
Paragraph 7.
Thirty-three kathas of land.
ছেড়ে দিন না, ছুটির আগে আর করবেন ছেড়ে দিন লর্ড সাহেব অর্ডার দিতে ছেড়ে দিন
I'll do this. I'll say that this order shall remain in abeyance. I'm not setting aside the order. This order shall remain in abeyance for a particular period, during which he will have liberty to produce all documents. He will hear the parties. And if you are not satisfied, you will confirm the same order. If you are satisfied, you will recall this order.
Please kindly note two things in the order. One is, it's a stand of the government that this land is unallotted. And we are not disturbing the slum dwellers. Only we are clearing the encroachment made by the petitioner
Yes, yes.
without any.
I'm not going to say anything on merits. It is only because his allegation is that he has not been heard. That is why I'm not even setting aside the order. Because he has not been able to ventilate his side of the story to the hearing officer
But
because of his illness.
Reasonable time.
Yes.
I'm very
limit it.
good.
Within that time, if he goes and if he satisfies, then in that case the authority will pass appropriate orders. This order, if he is satisfied, this order will not be given effect to. If the authority is not satisfied, the authority will proceed with this order.
I'm
And in that case, this he'll prefer appeal against this. He will be given a post-decisional hearing, is all that I'm saying. For that period, the order will remain in abeyance. And if the authority is not satisfied, the same order will continue.
And I shall be allowed to produce all documents in
Yes,
support
yes.
of my.
Post-decisional hearing means that only. I'll come back after recess and 1:20 now.
My junior will be present at the time.
Not a problem. You can also be present. I'll have the benefit for 5-10 minutes.
I just want to mention
Item number 5 is non-prosecution. All
Item number
5 is for non-prosecution. And say that my none of this all are present.
5 of today's list.
Today's is not mentioned.
Extension of entry model is also there.
You mentioned lordship item number 5.
ঠিক আছে 5 এ লিখে নিন the to be mentioned গুলো
I want to mention.
no, don't mention.
Extension of entry model will be taken second.
After this is over.
Get to
Yes. लिखे नहीं this writ petition
extension of entry model.
Extension গুলো?
There are 4 items.
আর to be mentioned একটা correction এর আছে সেটাও mention ফল করুন একটু।
Extension of entry model.
কারেকশনটা কল করুন। নেই চলুন নেক্সট।
Six, seven, eight. Extension of entry order. I am for the petitioner, my lord.
লিখে দিন this matter has been next.
I am appearing for the petitioner, my lord.
Affidavits are complete. Same order.
Yes, I am appearing for the petitioner, my lord. Lord, I am appearing for the respondent.
Affidavit?
Affidavit in my part, my lord, is pending. Due to the illness of the petitioner, I am not able to. Affidavit is ready.
You can file it today, no?
No, after reopening, we have filed.
This matter is appearing under the heading matter, Your Lordship. But there's just one. This matter stands released from this list on my personal ground. Let this matter be placed before the Honorable the Acting Chief Justice for appropriate order. Chalo.
Well, I am for the petitioner, my lord. Well, matter is very small for non-consideration of my representation by the
There was a direction for you to file a supplementary affidavit.
My lord, my lord. I am for the private response. Okay,
Serve a copy of the supplementary upon him. ওটা দিয়ে দিন supplementary. Did.
Well, kindly have a look copy of the supplementary. My lord. Page number, my lord. 7. Page number 7, my lord. Yeah. Well, that number subject. Subject. Sorry, my lord. Where my lord kindly stay.
It will go after.
Only my lord, just consideration of my represent, nothing more.
Very well. After the vacation, I'll be taking up. because you should have served earlier.
Well, my lord.
Supplementary affidavit filed by the petitioner in term
Five seventy, my lord, I am for the petitioner.
And I am for the respondent number 3, earlier development of
But I'll be candid, my lord. Mr. Supratim Dhar is appearing for the state along with Mr. Amritulal Chatterjee. I've served notice upon them, my lord, prior to mentioning. Only difficulty is, my lord, that for the private respondent, I've lost the, my lord, the.
Oh, no,
slip.
they are important.
They are, my lord, they has to be implemented.
The petitioner বসে লিখুন, এটা তো বড় বড় order নয়. The petitioner none appears for the petitioner. Full stop. A report in the form of affidavit has been filed on behalf of the
573, my lord.
Five 73.
My lord.
Yes.
73. Well, this is my exception. My lord, kindly take up the matter 573 and 74, my lord. Both matter are same, only the name of the petitioner is the different.
573 I'm taking up. Tell
My
me.
lord, my lord. My lord, it is the fact that petitioner is the landowner in respect of plot number 136, Mouja Belgaria, PS under PS Debra district, Paschim Medinipur, my lord. And my lord, there is a public land adjacent to the petitioner's land in question. Here the private respondent has illegally encroachment, as a result of which the petitioner is suffering a lot day by day because the egress and ingress has been obstructed. There is, my lord, peculiarity is that the road has been constructed by the PWD, road is maintained by PWD, but till date, land record is the name of the district board. Now, this has been renamed in the Jila Parishad, my lord. Previously, I moved a deed application under the purview of West Bengal, my lord, Highway Act 1964, my lord. My lord, kindly come to
Who is appearing for the private respondent?
So service is complete, my lord.
So service may be complete because of the change of determination.
In earlier petition, they did not also repeat.
No, they were represented 10 and 11.
My
They were
lord.
there.
My lord, I am appealing.
My lord, 13 and 14.
13 and 14. Nobody appeared. Okay, refused to accept. Very well.
My lord, kindly come to Annexure P2, page 23.
P2, page 23.
My lord.
Yes.
This is the order earlier passed, in earlier writ application, my lord.
Yes.
My lord, it is submitted, my lord. It is submitted that on behalf of the state respondent, the respondent number 2 may be directed to dispose of the representation within a stipulated period of time. Upon consideration of the submission made on behalf of the parties, material on record, the representation is disposed of by directing the respondent number 2 to consider and dispose of the representation submitted by the petitioner dated 23rd July 2021, my lord. My lord, this order is communicated by my letter dated 8 February 2022. Next, annexure page 25.
Yes.
Thereafter, my lord, the BLRO concerned went to the spot and my lord demarcated the land in question. My lord, kindly P4, page 31. This is written partly in English and partly in my lord vernacular, my lord. May I read? My lord, this is a black mark. এই চিহ্ন অংশটি অবৈধ দখলকার চিহ্নিত অংশটি অবৈধ দখলকার শ্রীমতী গোপালী মুর্মু ও তার মেয়ে বর্তমান পাকা রাস্তাটি 256 নম্বর বেলগেরিয়া মৌজা ও 250 নম্বর জেল নাম্বার বিশিষ্ট পাঁচগেড়া মৌজার সংযোগস্থলে অবস্থিত। 1 নম্বর দাগে মৌজা পাঁচগেড়িয়ার দাগ নম্বর 1 শ্রেণী পাকা রাস্তা ডিস্ট্রিক্ট বোর্ডের জমি, মানে কাইন্ডলি মাটি ডিস্ট্রিক্ট বোর্ডের জমি। উক্ত জমিতে পিডব্লিউডি দ্বারা পাকা রাস্তা তৈরি করা হয়েছে। What I am stated, my lord, just.
Yes, what is there in the report?
My lord, kindly next page. Page 32. After taking this report from the BLRO, the assistant engineer of the PWD concerned wrote a letter to the secretary, Jila Parishad, Paschim Medinipur, my lord. With reference to the above noted subject as per the direction of
yes,
the
I have read it.
My lord. My lord, thereafter no step was taken on behalf of Jila Parishad. Having no other alternative, the petitioner again made a fresh representation before
and
the.
Then this writ was filed. Understood. What is there in this report?
My lord, report 2, but kindly two things, my lord. One thing, my lord, they are shifting their, my lord, duties to each other. Previously, I moved a writ under the 1964 Act. In this writ application, my lord, PWD, my lord, requested the Jila Parishad to take appropriate for removal. Now filing another, my lord, when I file this writ application, another report is filed by Jila Parishad. Jila Parishad stand and three stand that since long back these two persons are there, there is a 3-foot gap passage, and PWD is the appropriate authority for removal. And I have that in exception, I have my lord
appearing for PWD. Yes.
My lord, as per my lord, I have not yet received a report, my lord. But as per the earlier direction, we have, my lord, conducted an inquiry, my lord. After an inquiry, it's found that the land belongs to the Jila Parishad. Now we have, page 32, we have communicated with Jila Parishad to take my lord as per case.
Where is the Jila Parishad saying that it belongs to PWD?
Yes, my lord. We have already handed over. My lord, kindly.
Where, which page?
My lord, they are their report.
Which page in the report?
My lord, page 4, my lord, paragraph 10.
Page 6 also, my lord. I started from page 6, my lord. Paragraph 6, page 3. But 2 stand they have taken. Kindly read out, my lord. May I read paragraph 6?
No, wait. If it is on the PWD road, who is the authority concerned to take steps?
My lord, the assistant engineer, my lord, respondent number, I'm seeing.
If then the PWD is the authority, but they have not added any document in the report whether that has been handed off to the PWD. They are only
Respondent number 2, my lord.
My lord, on the land, my lord, the road has been constructed by the PWD. What more document is required?
have to officially hand over the land.
Yeah, they have used without my handing over the document.
The record shows the land belongs to our Jila Parishad.
On that plea, PWD cannot shift, my lord, his responsibility.
The record shows the Jila Parishad is the authority, but they have
In that case,
we have inspected, pursuant to the earlier creation, we have inspected. After
Show me, assistant engineer is the authority. Show me under which provision.
My lord, under the provision of the 1964 Act. 1964
Show me
Act,
that.
my lord.
Highways Act.
It is the, my lord, state highway, my lord.
Which provision?
My lord, first, my lord, paragraph 8. Paragraph 8, my lord. My lord, sorry. My lord, section 8. Section 8. No parcel make any enforcement without obtaining previous permission in written from the high authority or any officer not below the rank of assistant engineer authorized by him in this. Therefore, my lord, kindly come to my lord, section 10.
So it is only for highways. Highway will have to be declared as such under section 3.
My lord.
Has this road been declared as a highway?
This is the highway, my lord. As because the cognizance has been taken by the assistant engineer, my lord. In my read application.
Cognizance of assistant engineer will not do, whether it has been declared or not. That has to come before the court. Then I shall direct any one of the authorities.
My lord, otherwise, my lord, I have came before lordship under the 1962 Act. My lord, the
1962 Act, they will have authority only if this is not there. Both the authorities will not have jurisdiction.
No, my lord, my lord, earlier, in my read application, I have annexed that memo. My lord, assistant engineer wrote a letter to the Jila Parishad to take steps.
Very well. Jila Parishad says it is not my land, it is the land of the PWD. PWD should say then whether there was a notification under section 3 or not. If that notification is there, then in that case they will have. Otherwise, I'll direct the Jila Parishad.
My lord, kindly take my exception. Kindly take my exception.
Yes.
My lord, I have the recent, my lord, status of the land. My lord, page 14. Page 14 of my exception. Page 14.
Page 14.
My lord. Recent status report of the land. মানে দাগ নাম্বার 1 শ্রেণী পাকা রাস্তা জমির পরিমাণ খতিয়ান নাম্বার 1 রায়ত হচ্ছে মানে ডিস্ট্রিক্ট বোর্ড মানে বটম রায়তের নাম ডিস্ট্রিক্ট বোর্ড মানে নাম জেলা পরিষদ।
So
No, my lord, record has not been corrected. After my lord transferring my lord the land.
You file a report whether this was notified under section 3. Then I shall take steps.
But kindly, next matter, there is
Let this matter be over first. Let this matter will come to.
One thing I inform, in that case, my lord, the assistant engineer has take the cognizance, issued section 1, 10(1) and 10(2) notice.
In respect of the same.
Same.
Then, sir.
I have not received instruction. This matter I have not received instruction.
Which matter?
This matter, sir. I said.
Next matter,
Next matter is the
same. Next matter is the same.
Next matter they have done this. This matter they have not done. What is this? If it is the same,
land.
it is
My
the
lord,
same.
in respect of same land, only 2 persons buy the land by two different deeds. So I make 2 deeds.
Next matter take to din.
In 74,
Yes. Next matter.
Fact is the same. My lord, I am only handing over the my lord. My lord, kindly see the 10(1) notice issued by the assistant engineer.
So they have started action in this.
And 10(2) they have started action, my lord. Next action 10(3) by the executive magistrate.
So this was done during pendency of the writ petition.
Yes, ma'am.
So this writ petition should go then.
Both are the.
If action has been taken on the basis of this, why should this writ petition?
Another 10(3) is.
They will take 10(3). What is the reason for me to believe that they will not take action?
No, my lord.
After, no. I will execute the order.
No.
Here. Then
After filing this.
This will go. This I will see. Wait. Yes, Ninto.
Lordship, this I have a report with me.
In respect of?
In
Yes, next.
But in this matter, I am for the petition. But the matter relating to the unauthorized construction for demolition, I have come before this court. But what happened, my lord? The land has been acquired, and it is irrigation and waterways land. But unfortunately, the name of the private respondent has been recorded in the record of right. But in the authority submitted one report that it is found from the report that the land has been acquired. Kindly have a look to page 29.
Page 29.
Yes, my lord.
Page 29, yes.
This is the report of the subdivisional officer. The last paragraph in this connection also stated here that said plot is fully recorded in favor of 5 numbers respondents under such and such, such and such, such and such. But according to unsigned land acquisition register of the office of the undersigned, it is found that the plot number 2538 of the stated Moja partly acquired 3.50 decimals. That has been acquired. And kindly have a look to page 32. Plot number 2538.
Yes.
2538. That has been recorded. And this is the inspection report.
Yes, sir.
Kindly see page 48.
48.
Operating part of the order passed by this honorable court in a previous petition.
Yes, ma'am.
Yes.
So may I please? In the facts of the present case, since there is a writing of the subdivision officer claiming that the plot in question is a government property, it would be appropriate to call for a report from the DM as to whether the plots spoken of belongs to the state or not. In the event the state finds that the plots belong to the state, no doubt the district magistrate will take appropriate steps. Because thereafter, my lord, page 58, your lordship kindly sees.
58.
58.
Yes.
But that petition, I am told that is pending, my lord.
No.
Yes, but this is.
No, that is not pending, that is disposed of. That proceeding for damaging out of an 100% proceeding. And that is Joyce. So what happened in that particular document, last part of that proceeding shows that acquired portion is free from all income transfers. Acquired portion has never been acquired imposed by people. If you kindly come to page 31. We were relying upon this report.
31 will
Yes, page 31.
Now, it may be said that the acquired area, plot number 2538, almost free from any type of encroachment is today.
Where are you reading? Page 31?
Page 30 last paragraph. Page 30 last 30. Page 30 last paragraph.
Yes, but this is of 2018.
It is, yes, because earlier they moved a repetition on the same issue, which has been dealt with.
Earlier writ petition was moved by somebody else.
No, by her husband. I have the copy of the writ petition. There I was made.
That is 140 against the 144. That is not proper application. So that was dismissed, not on the merit, on technicality.
Now can
Yes.
you see, husband made a representation before the authority that I have encroached the property.
Let the state file a report. Please file a report.
Yes, my lord.
File my opposition.
Let the report first come. Then
Yes,
we
my
shall-
lord. Yes, my lord.
This writ petition alleges. Writ petition alleges None appears for the petitioner, full stop. The respondents are represented, full stop. List this matter under the heading for dismissal on January 8, 2026. Next.
I'm for the petition. I'm trying for.
Not today.
For the respondent, my lord.
Not
For
today.
very short point, it's otherwise a cover point. A similar.
For time. Why?
This side of the vacation, it can be disposed of. Takes up this matter.
What is the point?
Well, this relates to, my lord, acquisition of a cultivable land under the Petroleum Mineral Pipelines Act.
It's under the Unauthorized Occupants Act.
Not unauthorized.
Then this will not be
like
my.
laying of a pipeline over the agriculture.
So
land.
this is not. This has to go out of list. দিন আমাকে দিন না
Petroleum Mining Mineral Mining Pipelines Act. Identically a covered matter. Last year had the occasion to.
Yes, but that was because of me having determination
Yes,
of
that
these
point of
matters. This is not a public premises eviction of unauthorized occupants act matter.
No.
It's not. লিখে নিন, since this code does not have determination comma, let this matter go out of list.
But I am for the petition. I mean, this is my affidavit of service.
Yes.
Didi.
Yes, Mr. Mitro, what is your instruction?
My instruction is.
There is an order.
The petitioner got sufficient to be given to the reality or authorized. The DL will send the matter to SBI.
There is a direction on you to file a report.
Yes, kindly give me a section to file a report.
No, there is a direction already.
Kindly accept it and give it.
Why are you not taking action on this?
Report, I have the report.
देखिए report टा देखिए.
This is the report. It was not in the form of an affidavit.
The order does not say form of affidavit. If it is a report, I shall.
That's why I am hesitating to hand over. On the annexure, sir.
দাদা আমাকে একটা কপি দিও।
নিশ্চয়ই।
It appears that action is being taken on your representation.
No, my lord.
You serve a copy of the letter.
Lord,
7th.
my case is not to consider the representation. Kindly have a look into page 23 first. Only the unauthorized portion to be demolished. Only
that has to be done in accordance with law. That
yes, my lord.
They will.
The prior formalities had already been done by the authority at page 23 of the writ petition.
No, this was by the BL and LRO.
Yes.
The subdivisional officer will have to draw proceedings under section 3 of the act and then they will proceed. That
My lord.
proceeding has to be done.
Yes.
The report also reveals that only.
Yes. I am for the petition.
My lord, in respect to item number one, this item I am appearing on behalf of state respondent, my lord.
This is my evidence.
Who is appearing for the private respondent?
I have served in the earlier round of litigation. No one has appeared on behalf of the private respondent. This matter relates to unauthorized enforcement under the provision of West Bengal Unauthorized Eviction Occupants Act 1962. The petitioner moved earlier the petition for removal of the same. Thereafter, the Honorable Court passed an order. In terms of that order, the competent authority, that is subdivisional officer, passed an order. That is that copy of the order of this court at page 68. Come to page
68.
Yes, 68.
Yes. Yes.
Thereafter, by following this order, the subdivisional officer passed an order, that is page 70.
70, yes.
May I read, my lord?
No, I have got it.
What
This has not
happened?
been implemented.
Not implemented. I have
Yes,
what?
state, you are appearing for the state authority. Why have you not?
My lord, I appear on behalf of state authority, my lord.
Yes, sir. Why have you not implemented your order?
My lord, what is happened, my lord, in this case, kindly see the page 70. My lord,
Page
the last
70.
two paragraphs, my lord, kindly see. Hence, in terms of such and such, my lord, accordingly, the head teacher such and such primary school, Bhopur, Purvendapur is directed to demolish the illegal construction within 15 days from the date of receipt of this order. And my lord, here it is, my lord, strict, it is directed upon the period to, my lord, demolish by himself, my lord, after assistance of the police authority. My lord, I do not find any, my lord, any application he has prayed for, my lord, for police assistance. Nothing is remaining in the writ petition.
Come to
So,
page
my lord,
75.
the order has been passed by the SDM.
Is it possible for an headmaster to remove the same without help of the administration? Kindly come to page 75.
Yes, your answer is there at page 75.
75 and onwards.
He has prayed for police protection.
Series of representation I have made.
Yes, my lord.
Then,
my lord, here in this case, my lord, if the petitioner, my lord, is prayed for after this order, my lord, police will give assistance for implementation of the order. But my lord, petitioner
petitioner has
himself
already prayed.
is the same.
There are several representations where petitioner has prayed for.
And lastly, on page 81, my lord, an application for implementation of the order dated 20th February 2025 passed by the subdivisional
8
magistrate.
steps to demolish.
School is
You
suffered.
implement your
Yes,
order.
that should be demolished.
This writ petition.
Malay, one thing may Malay point out, here this order also Malay served upon the private respondent. Malay, since they have
You first take care of your own order,
Yes,
then
yes,
what? Then think about private respondents.
No,
First
no
see
problem.
that your order is implemented.
My lord.
You pass an order, then you don't honor your own order.
My lord.
This writ petition is directed against the inaction of the respondent number 5, i.e. the subdivisional magistrate, Purbo Medinipur, in implementing an order dated
20th February 2025.
Page
70. Page 70.
Page 70. An order dated February 20, 2025, passed by the same respondent, i.e. the subdivisional magistrate, Tomluk,
Last paragraph is very vital. Page 70.
How have you made the two as different? They are same persons, 5 and 6.
Respondent number 5 should be.
Then you have written as subdivision officer is different, magistrate is different. Respondent number lekhar dorkar nahi, okhane likhe din subdivisional officer and subdivisional magistrate, Tomluk, Purbo Medinipur. Respondent number 5 is wrong actually.
Yes.
Magistrate will not be respect of a district, has to be subdivision.
The order is passed by the subdivisional magistrate.
By the subdivisional magistrate Tomluk itself. Full stop. Paragraph. Attention of this court is invited to the order dated February 20, 2025, whereby the subdivisional magistrate, Tomluk, held as follows. Copy hence, hence, paragraph. Page 71.
Malad, next page also paragraph is Malad most vital. Next page, page 71, first paragraph.
So let me pass my order. Please wait.
Malad.
Next. Copy kore din. Next, please. Upon the said order being passed, comma, the petitioner applied before the officer in charge, comma, Kolaghat police station. Applied before and applied to the officer in charge, comma, Kolaghat police station on March 20, 2025, seeking police assistance for the purpose of implementation of the said order dated February 20, 2025. Full stop. Despite such application, comma, no assistance was provided to the petitioner, and as such, the order dated February 20, 2025, passed by the said subdivisional magistrate, comma, Tomluk, remains unimplemented till date. Full stop. It is under such circumstances that the petitioner has approached this court by way of the present writ petition. Full stop. Paragraph. Learned advocate appearing for the respondent state authorities initially sought to defend the inaction on the part of the subdivisional magistrate by submitting that the onus of demolition lay on the petitioner himself, but upon it being pointed out that the petitioner had in fact applied to the relevant police authority, jurisdictional police authorities, seeking assistance for implementation of the order passed by the subdivisional magistrate, comma, the learned advocate appearing for the state respondents had little resistance to offer. Full stop. Paragraph. It has not brought to the notice of the court that the order dated February 20, 2025, passed by the subdivisional magistrate, comma, Tomluk, has either been set aside or stayed by the appellate authority. Full stop. In such view of the matter, it is taken that there is no appeal filed, there is no nothing which was demonstrated.
No appeal has been filed.
Full stop. Since since the state respondents, since it is not the case of the state respondents that the said order dated February 20, 2025 has been either stayed or set aside in appeal or in any proceeding higher up, comma, it has to be taken that the said order dated February 20, 2025 still subsists. In such view of the matter, comma, there is no reason for the said order to be not implemented and executed. Full stop. Accordingly, the respondent numbers 5, 6, and 10 are directed to take appropriate steps so that the order dated February 20, 2025, passed by the subdivisional magistrate, comma, Tomluk, in terms of section 5 within bracket 1 of the West Bengal Public Land within bracket Eviction of Unauthorized Occupants bracket closed Act, comma, 1962 is executed and implemented within a period of as expeditiously as possible, and preferably within a period of 2 weeks from the date of communication of this order. Full stop. WPA 10451 of 2025 stands disposed of with the above observations. Ekdom opore likhe din. Affidavit of service, private respondent has been served.
Yes.
Show me where.
The fact.
Which page?
Page টা কত আছে?
সবগুলো দেওয়া আছে 8 to 19.
Page 8 to 19. There is 13. All have been served by, and item is delivered.
None appears for the private respondents. Full stop. It is submitted by the petitioner that service upon the private respondents is complete. Eta opore likhe din. Affidavit of service ta opore.
Deeply obliged, my lord.
Thank you. Yes. আরেকটা কল করে দিন, অনেকক্ষণ ওই বড় মামলা চলবে তো।
Well, I am for the petition, Your Lordship. Earlier occasion pass an order, private respondent serve the notice.
Yes. You are appearing for the private respondent number 9 only. Yes. And who is appearing for the state authorities?
Earlier
State,
occasion, so earlier occasion present the state.
state was present. State is important because direction will be on state only. Passing it over, next state will be taken up again because state is the
Well,
main
kept on order,
record.
Your Lordship.
You want an order to be recorded? Just a minute. A few more appellate side, then I'll switch over. Then it's all right. Yes. Next.
My lord, I am for the petitioner. Pursuant to your lordship direction, I have made affidavit of service in respect of the private respondent file. My lord, my lord, no. I have sent it by page 2. Page 2.
I don't know which respondent Jala Board. It has been sent to me immediately.
3A.
No.
Pursuant to এটা 3A আমি করে this time.
Very well. You are appearing for Zilla Parishad, na? Very well. Yes. What is your submission?
My lord, it's that matter.
Respond
3A. Respondent number 3A.
What is the grievance?
My lord, grievance is this. My lord, petitioner, private respondents encroach the government land pursuant to the order passed by this honorable court. The SDO passed an order which is page 23 P4.
Page 23. Yes.
Page 23. My lord, in that order, it appears from the BLR report that the opponent house is situated partly on government land of plot number 104, measuring about so and so decimal, partly Rayati plot being number 105, measuring.
Yes, sir. What steps have you taken? Direction was on you to.
Taking steps for taking hearing.
What hearing? Hearing is not required.
Hearing
has been authorized. Read page 23. Zilla Parishad has been asked. It is your property. You have been asked to remove it. Take assistance of police and remove it. Taking steps will not do.
Yesterday I have got the bill. Yesterday I have got.
You file a report in the form of affidavit. What steps you have taken? Look on. The petitioner alleges inaction on the part of the respondent, state authority. I serve a
Grateful.
copy of this, a copy of a notice shall also be served upon the private respondent, intimating them about the returnable date.
By the petitioner.
Yes, yes, of course.
In the meantime, private pay for the short pass. After that, petition is not. Considering petition by
I'm
giving
the private respondent.
You are appealing for the petitioner?
No, private respondent.
None appears for the petitioner, full stop. The respondents are represented.
Let's appear for the
This will
portion
take
of.
time.
Yes,
So,
Your Lordship.
not today,
May I
not
just
every day
beseech Your Lordship, if a,
583.
if a time Your Lordship may be fixed on 8th, the next
583 is
Thursday.
concerned, Lord. Section 11 application has been allowed.
Yes, I wanted to see this.
Entire thing has been referred to the learned advocate and they
No,
have
no.
given
We'll make submission.
We'll hear this because today there is hardly any time.
Fix it after.
Well, at 8th,
लिखे
if a
दिन ओखाने
time
একটা লিখে নিন, heard learned advocates appearing for the respect. হ্যাঁ
Most respectfully that after receiving the representation of the petitioner through postal service regarding the above noted matter, the same was duly inquired into. Inquiry revealed that the alleged person had constructed a residential house in a plot situated in front of the residence of the petitioner. The alleged person also claimed that he had constructed the plot on his own plots of land, not on the government land.
Well, kindly see the sketch map 23, page 23.
Heard learned advocate appearing for the petitioner and the learned advocate appearing for the state respondents. The private respondents are not represented. The block land and land reforms officer, Domkol, district Murshidabad shall file a report in the form of an affidavit indicating as to whether the land which forms subject matter of this writ petition is a government land or not, and as to whether the same has been encroached upon by the private respondents herein within 2 weeks from after a reopening of this court after the ensuing Christmas vacations, full stop. List this matter for further consideration on January 29, 2020. That's fix. Next.
I am for the petitioner. This arises of an order passed by the district magistrate, not 24 Parganas. The petitioners before your lordships are running their business from the plot inside the Salt Lake Stadium. Now if kindly comes to the impugned order, page 61. The issue here is
yes,
that the land belongs to the sports department. Sports department obtained the land from the Union of India.
yes.
The requisition is for the eviction process is an entity by the name of West Bengal State Transport Infrastructure Development Corporation Limited. We took the point that at least at the behest of this entity, that section 3 proceeding could not have been drawn.
Why?
Because it's either by the lessee or by the owner. Kindly takes
No, that is not the
424. First come
Let us see 3.
3. Very well. If in respect of any public land, the collector is of opinion upon application made by an officer of the owner of public land. Owner.
Thereafter.
Public and authorized in public land. Owner of the public land. And owner of the public land authorized in this behalf by such owner or upon information received otherwise. Yes, yes, I'm coming.
Otherwise is broad. Anybody can come.
Coming. Otherwise, that the public land is in the unauthorized occupation of any person or persons, the collector shall issue a notice. Such form and containing such particulars as may be prescribed, calling upon all persons concerned to show cause before such date, not being less than 15 days after the date of the notice, as may be specified in the notice, why an order under subsection 1 of section 4 should not be made, and shall cause it to be served in the manner referred in subsection 2. Intimation of the date so specified shall be given to the owner of the public land and to his officer authorized under the subsection. Now, the affixation on the conspicuous part. The DM found that the notice was not in consonance with 3 subsection 2. But he otherwise held that the appellants before a lordship are unauthorized occupants and remanded back the matter to the DM, to SDM. Now, the few issues which has cropped before the the district, and that was a point also, that first of all, we have documents, agreements to sustain that we are not unauthorized. We are being inducted by the respondent number 2, who had a right of induction and subletting under the concession agreement of 2006. Now, the concession agreement says that for the exploitation of the
landed property or the subject premises.
Where
The-
is the order? Which is impugned?
Yes, the impugned order is at page 61.
61.
Yes. Now my lord will kindly come to Millard page 70 onwards. He has recorded the submissions. Yes, observation. From the hearing proceedings of learned SDM Vidhannagar, appeal petition filed before this authority and written notes of argument submitted that after the conclusion of the hearing by the appellant and the respondent number 1, following points of law emerge. It is undisputed that the land is a public land. It is undisputed that the owner of the land is the Sports Department, Government of West Bengal. Now, Millard, may I pause here for a moment? Millard, Sports Department was not made a party.
So all will be heard. That is why they say at
No,
last page of the order,
Yes,
page
yes, yes.
74,
Coming
he
to that.
says that the sports department will be heard.
No, he has hailed me as Millard, I am unauthorized.
Where?
Then return it back.
Where?
Yes. The appellants have disputed the initiation of the proceeding by the learned SDM Vidhannagar on the basis of the letter of West Bengal Transport Infrastructure Development Corporation. It has been stated multiple times by the appellant that the West Bengal such and such has no authority to provide said information, and the said information is insufficient under section 3(1) of the said act to start a proceeding for eviction. It was disputed 70. It was disputed that the manner of service of notice is not as per 3(1) and 3(2). It was argued by the appellant that the proceeding before the learned SDM Vidhannagar are not within the purview of law due to misjoinder and non-joinder by the sports department. Due to this, under section 4 of the subdivisions is deficient. It is further stated that the learned SDM are not maintainable due to stay order passed by the Honorable Four Arbitrator. There are many things to it. I am coming to that. It will take some time. It was argued that the appellant has subtenance
What
of
is the urgency, Mr. Dasgupta? Because I'll have to take a
Millard, on 23rd, he has fixed Millard the hearing, the SDM. I have no Millard, that's the only urgency. Millard, I had mentioned Millard.
will go on. What is the problem?
No, he will finish it off. He said that this is the last day because Millard, what has happened? On 8th, I have mentioned before a lordship. The date of hearing was fixed on 11th. Millard, somehow Millard, the mentioning slip got misplaced in the so many mentioning slips. Millard had fixed this matter on 11th at the top. But Millard, we inquired that 11th matter was not listed. Manual Millard, human error got misplaced. We mentioned on 11 morning. Millard was the view to mention before the SDM to take an adjournment. Millard, we took an adjournment on 11th. But he is of clear view that if Millard doesn't pass an express order restraining him from passing, he'll conclude on 23rd. That's the only urgency. If Millard adjournment, if Millard for the moment, Millard directs the SDM to stay off.
With greatest respect to my learned friend, every time there has been last time the matter was not
Correct.
Please let me finish. I don't want it.
No, I was just, you came up. I was not yet completed, sir.
Last time also when the court and your lordship was made some observation, I was told. Immediately I instructed the executor court that we heard out, kindly do not hear it. Your lordship some other day.
Yes, because it doesn't appear to be. It's not a demolition case that will be demolished.
No, the only thing, no. Millard thing is that he will conclude on 23rd. Millard, for the moment, if Millard both the parties,
you pray for another adjournment on 21st.
Millard, he is not. Millard, can you observe that?
This is not correct. This is not correct.
Kindly observe that. Very well. Kindly Millard, observe that on 23rd we'll pray for an adjournment.
Why? I'll tell you why. He wants to somehow obtain an order, then the matter will not be taken up. This is the track end of this matter. I can assure lordship.
I'll proceed with the matter.
I'll instruct the SDO. Any day your lordship fix, you fix a hearing after that. This much assurance I'll give to court.
Very well. He's saying this. Millard, kindly see 6th August order of the SDM. He recalled how suo motu this order himself. Millard, Mr. Banerjee, with all humility. Millard, kindly, yes, it's after. Kindly see the last paragraph. Kindly, this is the last paragraph. He himself said that I will not sign it. This is adjourned because this was pending before Justice Basu. Justice Basu, before the vacation, Millard went to Millard circuit.
Any assurance
But
to court.
Millard, the assurance was given.
Mr. Dasgupta, The last paragraph says adjourned till the disposal of the
Right.
petition.
He himself recalled this subsequently.
Where?
Yes.
Why? Because after that, they did not, after obtaining this order, they did not take any step for hearing. When was the matter next mentioned?
Millet, we have thrice mentioned before Justice Basu upon giving notice.
Please, when was after?
Millet, like this I can't come to Millet. Either it is
Wait, Mr. Dasgupta, please maintain some.
No. He was not there. He's being told, he's saying. When the judge was in circuit bench, therefore his list does not permit. What a Millet litigant should do? May I put the question to myself?
Very well.
Now, Millet, last day order, dekha. This is Millet, he has fixed at 4:15 on 23rd. And this will take some time. We argued for 14 days before the Millet DM. 2-volume notes was Millet submitted. And this will take some time. Millet, I don't want to detain your lordship with that. But the thing is that 23rd, if he concludes, Millet, I will get prejudice on this because he formed an opinion. He is otherwise Millet, he has already formed an opinion. Because he's the same person who is now hearing for the second time. This is the second round before him. Before whom we lost.
Very well. Mr. Banerjee, can I record that adjournment will be granted?
Yes, your lordship did not. I'll take your lordship where I am appearance for.
No.
The moment your lordship will record anything like this, the matter has an uncanny knack of running out of the list and is not taken up.
Well,
Your lordship, I'm telling your lordship did not record anything.
No. Millet, why Millet? Because
Mr. Dasgupta is.
Yes, let me finish. Yes, kindly don't match. Millet, why this? Millet, last day also Millet, Justice Basu Millet went what Millet Mr. Banerjee submitted. He doesn't go personally before the SDM. Millet, naturally his status doesn't match to go before the SDM. Now Millet, the SDM is of the view if there is no recording, I will proceed with the matter. Millet, suppose Millet 23rd is the last day before vacation. Millet, if he fixes on in Puja vacation, we did the matter before him. 30th Millet, if he fixes on Millet 26, 27, 31st, then no lawyer would be here. And how many vacation bench will get? My lord will also not be here. There's a difficulty.
Yes,
My lord, kindly record.
Give me a solution to this. Yes, Mr. Dasgupta, please don't interrupt. Yes.
I can take the lordship, this assurance. My advocate record is here. The last time also said, the lordship is not inclined to take it. Lordship can be rest assured that he will also go.
No, not question of not inclined. Time is not permitting that. Yes, because original side matters.
I'm aware from 3 o'clock is supposed to original side. I'm aware of that. I know. But that is why I don't. We've also put in years in this profession. We know the difficulties of court. So may I say this? As far as 23rd hearing is concerned, lordship do not worry about it.
26 तारीख fix করে দেবে।
My statement before your lordship.
No.
My word is also not there. I can assure you lordship this 23rd, he will also put in a joint prayer for an adjournment. Come back to your lordship whenever your lordship so decides.
Very well. So my lord kindly, my lord has
Your lordship accepts my
very well.
assurance.
No, my lord, with folded hands, my lord, with all due respect to my learned senior. He doesn't go. No. Very well. If 23rd, suppose Millet kindly take it. He is fixing within 5 days. He is fixing. Suppose on 23rd the matter is fixed on 26th. Who will take the responsibility?
Very well. Then I'll do this. I'll say that the hearing will be fixed immediately after the date when this writ petition is made returnable. That will solve all problems.
I'll tell you the trouble is that without any aspersions to anybody. The writ petition has a tendency, this happened once earlier, has a tendency of running away from the list.
I'll say immediately after that. There's no point of contempt.
Lordship will fix the date. Fix the
I'll be
date.
fixing a date. After that, he'll fix the hearing. So there's no problem. Even if it goes out.
ঠিক আছে
Heard Mr. Dasgupta, learned advocate appearing for the petitioner, and Mr. Banerjee, learned senior advocate appearing for the state respondents. For the state respondents.
No, he's for WBDL.
For the respondent number seven. For
WBSTIDCL.
the respondent number 7. Full stop.
My lord, Passover matter steady here, lords.
Which Passover?
Highway.
No, now original site. Next day.
Lords.
585, 585. Same order. नाम लिखो
Maintaining the original site. Item number 1. Affidavit site. लिखे नहीं. This matter is appearing under the heading extension of interim order upon being mentioned. Affidavit filed. ওই সেম অর্ডার করে দেবেন মিস্টার দুধুরিয়ার জায়গায় মিস্টার শর্মা নাম এনি item number 3 affidavit is complete very well সেম অর্ডার করবেন শুধু নামটা মিস্টার ভট্টাচার্য
3, 4 and 5.
number 6
For the petition,
not complete same order করে দিন নামগুলো শুধু
this is a GST matter, my lord.
very well
I'm grateful.
extending the time to file affidavit by 4 weeks from date reply 2 weeks extended till end of February matter will appear immediately after expiry of the time fixed for extension
I'm grateful.
yes
filed this G application asking for a prayer of extension of operation of the interim order. Also, this is a writ petition where I have given a show cause for eviction under the Enemy Property Act. I have challenged that. Lordship will come to page 8 once, Lordship, of the application. This is an order passed by Justice Sengupta on 19 March 2025. The Lordship comes to page 10 of the order. Actually, last time the impugned show cause notice shall remain stay till 21st April 2025. Now, after 21st April, Lordship, we tried our level best to get the matter posted, but somehow
It could not. Then the matter, Lordship, appeared on 30th of June 2025. That, my Lord, on the next page, page 11, is the cause list, where my Lord will find item number 2. But on that date also, it could not be taken up, Lordship. There was a verbal undertaking given that they will not proceed with the show cause until the matter is being heard. So we remain silent. But now the matter is being taken up by the state officer, Lordship, and last date was 15th. And he has given an extension after we told them the matter is in the list of my Lord. What I am beseeching my Lord is that where Lordship, when if the matter is, as and when the matter is taken up, my Lord fixes any time to my Lord. This the show cause notice, the state officer stays hand away from proceeding with the matter.
Yes, Mr. Tiwari.
I am tenant from 1955, Lord. The act came in 1968.
What I have said, that then the proceeding goes on long, I will not pass that. Now they are taking so was still there. Now the similar their cases, they are governed under the their cases, they are governed under the now this point
Recently, Subhas Pople was, I was looking at it. Subhas Pople was over.
Nothing is after this judgment. Nothing is.
Surely, I will demonstrate, Lordship. There is an agreement between us and the estate officer. There is an agreement
because
the 2008 agreement, my Lord. 2008 agreement. I demonstrated.
The reason for imposition of interim order was Subhas Pople. Pople has been overruled. So the basis goes for the interim order. There is no interim order. Imposition of interim order will difficult.
Fixes the matter any time next opening of the.
18 lakhs 92,000.
When is the next date for hearing? Before the
Lordship, the range from 6,000 is jumped to 1 lakh rupees, Lordship. I am deciding there, Lordship, from 6,000 rupees.
This one was the last date because that
they have not replied to the show cause.
no, nothing. They are not paying the rent also. 18 lakhs and what is due and payment. Let them pay or will not proceed.
Lordship, from 6,000 is jumped to 1 lakh rupees. Lordship, suddenly, like,
And
I'm
when the interim order expired in April.
In April, Lordship, we kept on persisting that.
Application has been filed in December.
Lordship, I mean, it fell from Lordship that file an application, only then I'll.
Yes, of course, has to be.
Yeah,
because it can't be orally done after interim order expires and such a long time passes.
The Lordship, the matter came.
You file an opposition to this. To this application. Yes, that is why you, so that it can be heard and finished.
Lordship.
I'm not passing an interim. You'll be passing an filing an opposition to this application for reimposition of the interim order that you are entitled in view of Subhas Pople. GA1 of 2025 is an the entire thing will go.
Notice one more small request out of that. Original side matter we kept at 10:30 in the morning. Yes. Just
Original side matters are very less.
just on one day 10:30
They're very less in number. Chalo, next.
Confusing method, item number 8.
No, no, not at all.
The way the application is framed, but I find that the key association name has been given first. Perhaps is not, they are not giving Scanpulot, perhaps the secretary whose reference name was the case. Then at least the individual comes in agent. And let us see the issue. The issue is with regard to the notification, but I understand the direct demand and the notification with regard to the multi-origin formula. But we are all interested. I also understand that the last leg of the submission permits us to time to intervene and whatever submission we consider consumer. But because it's a repetition, that's why it's not an induction or a suit procedure. And whether it concerns all our members. That is why we're careful.
Very
we have 200, more than 200 TR, which are taught. That's absolutely correct. What is what that the way this is not the correct way to. So it's a trust that every all the trust in the formula.
Because trust is an obligation.
All trust, absolutely.
Trust is an obligation. Trust. Somebody who approaches writ court has to be impregnated with personality, either juristic or natural.
Absolutely.
Both are absent.
Absolutely.
And it's an obligation. It has no character of personality.
Correct. Correct. Absolutely. I'm on that's one of the first thing I said, what is absolutely correct. One of the only way I can perhaps say my application is one of the century as the person whose wants to be repeated. It's one of the tasks level. Because we have several members, I also have the authority the authority the minutes of the committee meeting itself. We have given the extract, we'll put it on the supplementary article, I think we'll change it. And it's a repetition, we are affected, will kindly bear us over at the end of the that's one.
In the reply, my lord, this first thing is that what he says is in the case of a trust, trustees are members and someone representing the trust can sign it on the resolution of the trustees. He says there is no trustee. What I submitted is the person who is coming forward is really a type of intruder. Now, if my lord, we kindly see the page 36, it is not a trust. It is something which has no legal persona, because come to page 36. When this yesterday it was given to us, we think all it is correct. Why one will go and scrutinize everything? We believe advocate's statement to be correct. Kindly see paragraph 83, page 36. It is not a trust at all. There is no ingredient of a trust. Let him file if they pay it 3. Every member of the association undertakes to contribute to the assets of the association in the event of the same being wound up during the time that he is a member of within 1 year. This is not a thing related to trust. Trust is not wound up like, it's not a matter which is to be wound up. So this document is not at all which on the basis of which they come has any resemblance of the trust. Then paragraph 84, can you see this? If upon the winding up or the dissolution, I don't know that whether the trust is wound up or dissolved. Is like this. So, the person who has come is an intruder, and he has filed a petition, intervened in a petition. At the reply stage, finally, by making all incorrect statements, for which really I will say this, that I can raise a contempt application and my lord will be imposing a exemplary cost, that the person should not intervene in the running proceeding when he is only such a bystander who says my commercial loss can be. What is his commercial loss in the association of which no exporter has come in? But I can understand any exporter can come in if he has an aggrieved, etc. No exporter is coming. Person who has come has no legal persona. Who has come, if I ask to myself, so this name is a fictitious name. Whatever the name, it does not matter. Either the proprietor or the trustees, or if it is a registered association, in that case, that gets a legal persona under the law. Here, the person who has come has no legal persona. He says, I may be heard. What he says, my members are suffering because I am making a good export and his market will go down. And when his market is going down, he says, I am aggrieved by this. Policies are made by government. Government is to defend its policy. It is not that the private individuals will be defending. Person who is aggrieved, he can only come. He is not saying I am aggrieved. He says my commercial interest is that. What the Supreme Court has said in the judgment which I have given. Commercial interest is not the relevant thing. If that person is aggrieved, in that case, that notification certiorari prayer, he can come and challenge. He says, I am not concerned with the notification. It is not hitting him. It is not. What is the locus standi here? He is nothing. That is what the that paragraph 33 of the judgment of Supreme Court. They are interlopers, really, who watched the proceeding. This writ petition was filed in June. What they did, something all illegally, they have done it. Last 1 month, all exports have crashed. Now, when the matter came at the fag end of it, when I was in a reply stage, one person comes and says, at that stage, I may be heard without any application. My lord said, you file an application. Now, the person who has filed had filed the application without any legal persona. A petition without any legal persona, how one can deal? Who is appearing for the petitioner? There is no petitioner. It is vacuum. It should be dismissed and with exemplary cause, and I should be given liberty to proceed against this person for filing this kind of a petition, which certainly is contemptuous.
Yes, Mr. Tiwari. There was a form handed up to court yesterday. Yes.
Whether the term multi-audit is there in the Act or in the rules, regulations, bylaws, or in the getting notice. Can you take a supplementary maybe once?
Yes, I've got it.
Yes. Comes to page
34. Yes.
You also get it's a form E. But it says it comes from paragraph 11(2) of this order, control order. It says format of certificate of origin non-protected. You also item number, serial number 8. You also find origin
Criteria.
C notes.
Page 35.
Notes, number 1. The eligibility criteria to obtain certificate of origin. Any exporter of tea shall be eligible for obtaining a certificate of origin that confirms the origin requirement under any of the following conditions. A. Be wholly produced or obtained in India as defined in para 2 below. Next, B. Be not wholly produced or obtained provided that the same under para 3B. Now, subsection 2. Only produce or obtain, what is the meaning? Within the meaning of para 1A above, that T shall be considered as only produce or obtain in India if the same T is manufactured from the leaves of India. No, only in India. But if it is not manufactured from the leaves of India, grown only in India. So it is not originated from India only. Next, C. Not wholly produced or obtained within the meaning of para 1B above. Para 1B above. These shall be considered as not wholly produced or obtained in India. Any portion of the tea manufactured from the leaves of India grown outside geographical limit of India, but final process of manufacture or production, mixing, blending has been performed within India. This is not called conquering. So whenever there is a mixing, you are procuring some tea from outside the geographical limit of India and mixing it, then it comes under the ambit of multi-origin. It comes under now second question. It is to be made in box 8 of the certificate of origin. Can you see? A. For tea wholly produced or obtained as per para 2 above, they enter the word India in box 8. Now we are B. For tea not wholly produced or obtained as per para 3 above, enter the word tea India not less than 90% by weight of tea. In case the Indian content of the export is not less than 90% by weight, and if this condition is not fulfilled, then the enter the word blended tea of different origin and packed in India. In box 8, along with the details consignment of tea, the separate sheet as per format below. The name of the exporter, name of the importer, IEC code number, gross weight of tea, is the consignment, main weight, kgs, consignment, details of includes, used export product. Next, country of origin. That is details of quantity of tea or different origin and origin of another food and consumable unit in export product. So whenever you are exporting the tea, whenever you are importing the tea and mixing with the Indian tea, then it becomes a multi-origin. But in the rocket sign is not required for the purpose of ascertaining the meaning of multi-origin. Multi-origin means originated from different countries. So there, what my understanding is afraid of, what he is doing, but a person who is coming to the court come with clean hand. What he is doing, Lord, he is mixing, blending Indian tea with the foreign tea, and ultimately he is exporting as Indian tea. So what he is doing, this is absolutely not prejudicing the India's interest in the international market. Now he is not referring the Customs Act. Now he is referring the other acts and all the Tea Act or all this act. The Tea Act itself, a self-contained code. Everything is there in the Tea Act itself. These, so far as not his two notifications he has done. Both the notification, one of the notification he has been compliant. Another notification he is saying that this notification is not issued in terms of para 31 of the control order. Now that so far as para 31 I have shown to you that the para 31 is applicable in case of direction. So far as directive he has given a separate meaning. Direction and directives cannot be treated as at part. And not only that, these things absolutely clear. Notes of this control order, that is, and this judging from paragraph 11(2), then it is absolutely clear if the things of different origin, then it should be not multi-origin. Absolutely, I just showed you one thing. Other exporter what they are doing. I am just showing one document to your I am having one copy. But I have a look at this. Now can you see this is commercial invoice. Exporter name is there. Now can you see country of origin of goods, multi-origin, multi-country origin. So the other exporters are doing this, and he is saying I cannot fill up the forms and all these things. What he is doing, This is basically not, he is not committing fraud with the rest of the absolutely a person coming to the court with absolutely unclean hands and in extending the scope of the T Act, rules, bylaws, regulations, and its control order by referring the customs and for the last question, my lieutenant has submitted one form. Can you take this form?
Yes.
Now, this is the customs form. Firstly, I will submit the customs form does not apply. There are key act, key rules, bylaws, control order is there to cover up all the situations.
No, his point was that since it is a material for export, it will have to be exported in terms of the customs laws. Now, if there is a form which is specific for tea export or for exporting anything where origin is supposed to be mentioned, and all of it is now digitized. If the drop-down menu does not have any option of multi-origin, then what will happen? How will he export? No, this is an invoice. In this form,
shipping bill.
Can you see? It says on a state of origin of goods. You'll also find there is a
yes,
state of origin of goods. State of origin of goods. By London has annexed the.
Yes, that is what he has annexed. He says that this expression multi-origin is absent here. So how will you?
State is not the state of the state is different state in India. That is not state. Jammu Kashmir, Himachal, Chandigarh, Uttaranchal, Haryana.
I'm sorry, let him give shipping bill also. That is the part of declaration. Only incomplete declaration won't do. What is there in the invoice has to be in the shipping bill. If there is a mismatch, it will be confiscated. So if he says the declaration is multi-origin, let him show.
I can produce the entire file.
No. This is not something. When he has, if he has, what is what is the number? He has deleted the number. I can't find out. Yes, which number? Shipping bill number.
You also get all this number. Export names is also there. But so far as my understanding,
Yes.
Let him give
He
me.
is entitled to redact that because those may be confidential information.
This is what we do. They are given us how to talk. In this document which they have cited is this. I am fulfilling requirement at page 35, which is read, where I am giving multi-origin, giving all details, goods not wholly produced, imported goods used, details of that. Now, entire fighting is related to what? This one small box where it is said multi-country origin, where I am putting Indian origin. My certificate of origin is to buy where it is said that it is used in the mixing of the one. It is
that was issued by not competent. I am not.
So it is only.
I have shown you on the last time. So far as tea export is concerned, my London pen blood has produced a certificate. Which was issued by an authority not competent.
That's not challenge. That's not the affidavit. Also, nothing in that.
Evidence is not required.
Very well.
This
will not go back to what has finished.
So this is invoice something for the customs purpose. So now my document vis-a-vis his concern is all complete good. My document vis-a-vis customs, vis-a-vis international, vis-a-vis the other law who will be receiving this goods, they must understand the language which is spoken already. Customs Act is all this is internationally law framed. If they make certain provisions which is there within the internal boundaries of the T Act, I have done that. I have given them details of input, output, all details of that. On that basis, they have given the certificate. In my certificate, in the body of description, I have given imported tea, etc., etc. Now, I have given here India in accordance with the policy, import policy. Because import policy says the procedure that in case of, I have, in my reply, I have annexed at page 164, that rules of origin under the Act, Indian law, rules of origin. It says, can I one page 164 of my reply.
I've seen that.
That is my page statutory regulations under the Customs Act, which says rules of origin goods, imported goods have been used for the production of export product. It will be Indian goods. Then it will come in the second category, not wholly produced. I said to I explained to the court that wholly produced and not wholly produced have certain meaning. Meaning
That,
is
Mr.
that,
Mehta, you do not need to repeat.
we have to, nothing has no ramification with this, that multi-origin. We are not at all concerned with
So,
multi-origin.
Mr. Tiwari, your submission is that even with the expression multi-origin, it can be exported. These forms can be filled out.
Because in this situation, you have to find that custom is also not a party. What is going on or what is going on in custom, I do not know. Not only that, not 2 pages. I just showed you the loss. Can you have a look at page 78 once? Other entries. Can you?
Page 78.
Page 78.
Yes.
Now, can you see page 78? You also find the origin criteria. Indian. And can you see total 400 paper sacks. Indian tea, standard 3962, Assam track in paper sack with the plastic. Now, in his declaration, he has admitted that he is making blending.
Yes, admitted.
Admitted.
Yes.
Now, whenever a parcel is blending, it comes under that envelope. It is a multi. When other exporters are doing this, he cannot earn money at the cost of country's pride. What he is doing, with deepest of respect, I am repeating, what he is doing, this is not fair business standard. Absolutely not. Well, now he is not caught, now he is challenging this order. This order was issued in the year 2021. Everybody is complying with the same. 27 December 2021, this order. Everybody is complying with the same. Now, when raid was conducted, he was found, so called issue. Now he comes, your lordship was saying that this is ultra-virus to the thing. This is ultra-virus to all these things. Now all these things are coming. So basically, what he is doing, this is not absolutely fair. He has not come with clean hands. They should be thrown out. And on the last question, I shown to your lordship, so far as export of tea is concerned, the person who has issued the certificate is not competent to issue certificate. So far as export tea is concerned, there are other persons that is in West Bengal, BCI, Inspectorate, India Private Limited, Messrs. Cargo Inspector and Superintendence Company Private Limited, and tea.
Just a minute. There also something was shown.
Yeah.
Yes. Your last was shown, page 17, item number 7. This is appendix 2E.
दिखाना उसका जो लिस्ट
Yes, page 17, item number 7 was shown.
Page 16. Page 16.
16.
Prior to that, page 1.
Page 1.
Page 1, appendix 2. It says list of agencies authorized to issue certificate of origin non-preferential. Next, on page 16.
16.
This is West Bengal.
Yes.
Now, in West Bengal, you will have to find there are 9, 10, 11 establishments are there. Now, next, for export of tea only, you will have to find HON'BLE.
No. Serial 7 is missed out. Serial names there.
I am making submission. Please take your seat and thereafter you take your submission. Can you see?
Oh, that is. I have got it. This is only for.
Next, page 19. Page 19, you will also find in West Bengal only three entities are there. As you also got it from page 19. That is not for export of tea in for export of tea only, the West Bengal, number 5 is Messrs. BCI Inspectorate India Private Limited. Next, Messrs. Cargo Inspectors Superintendents Company Private Limited. Next, Messrs. Tea Research Association. These three persons can issue certificate only for the purpose of exporting tea. Now, who has issued this certificate? So, far as my reference time is concerned, can you have a look at 78 once?
I've got it. So this appendix 2E, this list is of list of agencies authorized to issue certificates of origin for non-preferential. So far as export of tea is concerned, it is only those 5, 6, 7.
So the entire thing got with difference of reciprocal and just 65 annual got with difference of reciprocal that so far as this notification is concerned, this notification if you are watching today, set aside this notification that page 40. My librarian is telling page 42, but it has a huge ranking. It has huge ranking. Now so far as this notification is concerned, this was rightly issued in terms of parameter. I am not repeating. And this is not coming with the purview of directive, not directions. And so far as other exporters are concerned, today you are losing time to consider one thing. Today, if this notification goes, the money which he has made by illegal way, that will be given premium to him. So these are
Yes, Mr. Banerjee.
Yes, I will put not there. I will even if so he is really representing the PSU in a direction. Or what for what I do. You are in the nature of a public interest. It is not a question of owner anymore. One individual person challenging a notification of infringement. What he is doing is what he is now branding his exports as one as if the tea is all of India only. This one is a misrepresentation. Now, who am I? I am not a tea grower. I do not grow tea. I am an association of tea growers. I grow Indian tea. What he is doing is what he is mixing the Indian my Indian tea with a cheaper substitute and is misrepresenting in the world of wherever it is exporting as if they are not of Indian origin. As a result, he is obviously making profit. That's one aspect is making profit. That's commercial aspect. Second aspect, he is misrepresenting the Indian tea growers who are making Indian tea by saying that it is all of Indian origin. With great respect, in a reputation, it is not like a soup. That one of the locals is strictly judged by the fact of whether you are party to super. Here, it is only to be seen by court whether I have an interest in the subject matter of the reputation. I did everything in myself. That's why I started speaking today. Yes, I come later because I thought that was it was being asked. The keyboard is going to be made apart. The other affected person has not been made part. You know, today the court feels that they call upon me to say Mr. Gandhi make your submission because you say that you are not guilty. What is your view on the fact of challenge of a notification of 2021 by one single exporter? And now that I hear that the other exporters might naturally want because one of this notification of 2021. If there was being a breach of that notification by other exporters, then they would have been held up. Now, quite naturally, they are going to
The other exporters will not maintain it. It will be one exporter who has been given a show cause notice. Who rushes to court to say, I want to challenge 2021? Just from hearing what my learned is saying, I don't know whether one has seen the key control order one trying to look at. But you also find one at this moment I'm submission. Once for a kind of 5 minutes to 10 minutes, either I can finish today or 5 or 10 minutes more, I'll come and finish my submission. I was making one request to try to get a copy of the petition from my learned at my cost.
That you can always do.
I will write to him, let him give a copy at my cost, so that I can make a submission which is more, which will be of assistance to court. So today the issue is, it's not a private issue. So the exporter might want to make the court feel it's a private issue, but it is not. Because they are all affected. All tea growers in India are affected. All manufacturers of tea in India are not affected. And I represent that given that about 160 members. 160 members for I it can't be a technical argument to say, oh, you're actually I don't know what all my learned friend want to do. Impute against me contempt, you are no one. Great benefit, who's my learned friend? Okay, one exporter. Challenging a notification of 2021. Since Muller is asking me questions, I would also like to ask him, where are the other exporters who have challenged? What is this one exporter who is come because Muller is given a show cause notice and because he is stopping the notification of 2021, that Muller is asking for what? I am asking Muller target locus. After Muller 4 years. Muller, I'll come Muller with Muller this. I want to show Muller the control order where Muller I find Muller there's some question Muller origin and all that Muller are there. I'll try Muller, I assist him Muller, try and Muller assist the court the rest of my. After that Muller will decide Muller on my application and Muller whether Muller is tomorrow will be.
Well, only one request is this, that either my learned friend produce the whole set of this document
Not required.
to the court.
Not
to the
required.
court.
Not required. I will not. Heard learned advocates. Heard Mr. Mehta, learned senior advocate appearing for the petitioner, Mr. Tiwari, learned senior advocate appearing for the respondent, and Mr. Banerjee, learned senior advocate appearing for the applicant in GA1 of 2025. Full stop. List this matter. Calcutta did tomorrow under the same heading for further consideration. Yes, it will be at 3 only. No, 3 it will be, should be at 3 Friday. It's an urgent matter.
Yes, kindly.
What is the urgency, ma'am?
The breakdown meeting was already given. They will finish my house.
When?
This week I have gotten.
No, there must be a date indicated in the notice. They usually give a date. No, but which is the date of demolition? That will make things easier. Which date has been indicated in the notice?
First.
21st. It's an appellate side matter. Didi. But your other side has to be here. Ex parte will not hear. Make sure he is here. Urgent matter है ओनर मैटर तक 595 আছে কালকে একটু উপরে দিয়ে দিন 10:30